Yes.
Number 9 of when they proceed to the council has come from Calcutta. And you cannot anytime.
Sir, we cannot assure you. We will try our best.
I am permitted to mention one matter, Lordship. Today's list, item number 11, council has been came from Calcutta, but kindly be taken today, Lordship.
We cannot assure you. Let us see how we proceed. Huh.
Item number 1 and 2.
1 and 2, I'm appearing on behalf of the appellant, your lordship. In the first paragraph of the order dated 18th of December 2025, the sessions case number has been typed as sessions case number 52 of 2021 instead of 12, your lordship.
अरे ये दोनों पिटिशनर नहीं है एडवोकेट क्यों कुछ is 2000 by reason of a typographical error in the first paragraph of the order dated 18 December 2025, comma, the sessions case number has been incorporated as quote unquote 52 of 2021 in place and instead of 50 quote unquote in place and instead of 52 of 2012.
12.
Stop office is directed to effect necessary correction.
One indulgence, your lordship, let all the parties act upon the server copies. Otherwise, if before the vacation, the applicant wouldn't be released on bail, your lordship. This is the application. So let this order be affected along with the.
Naturally, we won't take it back to Calcutta. We will finish it here.
Yes, your lordship, but let all the parties.
We are not to be reminded about that.
Pardon.
We know our responsibilities.
Pardon, your lordship.
The above rectification shall be deemed to have been incorporated in the order dated 18/12/2025. Stop. All other portions of the order dated 18/12/2025 shall remain unaltered. Urgent certified. This is at only one place it cuts.
Lordship. Grateful, your lordship.
You will get it in the server today.
Grateful, your lordship.
That is what you wanted.
Lordship, let all the parties act on the server copy because earlier we had to apply for the certified
আচ্ছা
copy.
ওটা লিখে দাও
That is the only indulgence I
all
was
the
seeking.
parties ওই যেটা লিখে দাও directed to act on a server copy of
Deeply obliged, your lordships. Grateful, your lordship.
তাহলে আর আর্জেন্ট ফটোস্টেট জেরক্স কপি দিতে হবে না। দিতে হবে তো?
Grateful, your lordship.
Item number 3 to 5.
নর্মাল দিতে হবে নর্মাল সার্টিফিকেট কপি যেন পাবে যেন পেয়ে যাবে
উল্লেখ করে তো
তারপর ওটা রেকর্ডে রেখে যাবে আর না হলো কালকে ওটা ফাইলে দিয়ে দেবে গভর্নমেন্ট।
Item 3 to 5, I'm appearing for the School Service Commission with Supriya Dubey.
I beg to appear on behalf of the appellant in Mat 110, my lords.
আচ্ছা what is the other writ petition which has been
Milad, other writ petitions is milad on similar relief, including milad one of the milad petitioner was milad assaulted or attempted to be murdered milad, and that also milad is part of that second writ petition.
oh you are also appearing in
Second writ petition.
আসুন। রেকর্ডস উড 1 নম্বরটা দিয়ে দাও, 1 নম্বরটা 1 2 করে দিয়ে দিও, হ্যাঁ? আর ওনাদের ইয়েটা না, অব্রত আর ইয়েগুলোকে অফলাইন অনলাইন করে দেবে। কালকে ছিল, আজকে নেই। না, এখানে তো এই শুধু অভ্রত যে অভ্রত সৌম্য, এই দুটোকে অনলাইন পাশে লিখে দিতে পারবো না? না, আজকে তো ওরা নেই এখানে, আজকে তো এরা এখানে নেই। Records would reveal that 15 writ petitioners claiming to be qualified for appointment to the post of assistant teacher in secondary level of government aided schools preferred the writ petition being WPA 1089 of 2023, alleging that about 313 voluntary teachers, VOLUNTERY, were appointed in derogation to a Darjeeling Gorkha Hill Council, bracket A, hereinafter referred to as DGHC, bracket close, notification dated 30th July 2010. এই 30th নাম সবকটাকে নিউমারিক্যালি দিয়ে দেবে, 30.07.2010, and a Gorkha Territorial Administration, bracketed hereinafter referred to as GTC. GTA, sorry. Memo dated 25th June 2018, and inter alia praying for issuance of necessary direction upon the respondents. এখানে দাওনি আমি যে বললাম ওই আর কতগুলো ফাইল ওইটাই দিলাম। না, এটার সাথে আরেকটা ছিল তো, ওই যে দেখো ফ্ল্যাগ করা আছে। হ্যাঁ, রিট পিটিশন। দেখো আরেকটা এরকম উপরে ফ্ল্যাগ করা আছে, এরম ভাবে আছে, এরম ভাবে দেখা আছে। হ্যাঁ হ্যাঁ, কি বলে, inter alia praying issuance of necessary direction upon the respondents to set aside the regularization of all teachers who have been appointed after 30th of July 2020, 30th of July 2020, 2010 in GTA area, and for setting aside a memo dated 8th March 2019 issued by the Principal Secretary, School Education Department, Secondary Branch, Government of West Bengal, without impeding the voluntary teachers who are presently working in different secondary schools. Stop. Applications for intervention applications were preferred by the said voluntary teachers and the same were allowed. Stop. A further writ petition being WPA 1162 of 2025 a further writ petition preferred by trained unemployed youths welfare organization and another being WPA 1162 of 2025 which was heard along with the writ petition being WPA 1089 of 2023. Stop. An application being CAN 6 of 2025 was also preferred by two applicants in WPA 1089 of 2023, urging an issue of maintainability. Urging an issue of maintainability of the writ petition. Stop. By an order dated 2nd December 2025, comma, the parties were directed to exchange their affidavits observing inter alia that, quote unquote, the issue raised in the application will be considered at the time of final disposal of the writ petitions. Unquote. Stop. Subsequent thereto, the judgment dated 17th December 2025 was delivered, directing inter alia that the impugned letter bearing number 254-AC/S/4 capital A /1 capital B /1 5 1 capital B /15 within brackets PT dash Roman 11 is a page 181 a পেয়ে যাবে dated March 08, 2019, quote unquote, যেরকম দেওয়া আছে সেরকম দেবে, whereby and whereunder the engagements of 113 voluntary teachers were regularized by the Principal Secretary, School Education Department, Government of West Bengal is set aside and quashed. Stop. Mr. Obrotosh Mojumdar, learned senior advocate appearing for the appellants in MAT 110 of 2025 submits that there was a complete breakdown of law and order situation in the hill areas of the state of West Bengal due to the outbreak of the Gorkha land movement. Stop. the operation of the West Bengal School Service Commission bracket A Hill region was suspended by a notice of the School Education Department dated 5th September 2003. Stop. In the backdrop of such political unrest, there was no recruitment to the post of teachers in GTA area. Stop. In such prevailing situation, the schools of in such prevailing situation, the schools of the GTA area became completely dependent upon the voluntary stroke temporary teachers, who were the local educated youths coming forward to render self-service. Stop. Being oblivious of such fact situation, the impugned judgment was delivered, rendering the said 113 voluntary teachers jobless. Stop. In view of the judgment impugned, the students would also be the sufferers who shall appear in the ensuing Madhyamik examination scheduled to be held in the month of Madhyamik is in which month?
February, my lord, February.
February 2026. Stop. Next paragraph. He argues that about 100 voluntary teachers have already been regularized on the basis of orders passed by this court. Stop. About 439 voluntary teachers appointed prior to 2007 were also approved and regularized by the cabinet. Stop. In view thereof, no different yardstick can be applied to the similarly situated 313 voluntary teachers. Stop. Such argument as advanced was glossed over by the learned single judge, and no finding was returned on the said issue. Next para. Mr. Shomu Mujumdar, learned senior advocate, appearing for some of the teachers amongst 313 voluntary teachers, submits that the memo dated 8th March 2019 had been set aside, it a paragraph 4, take care, had been set aside, প্যারাটা আরম্ভ করে দেবো, had been set aside primarily on 2 grounds. Stop. First, as such appointments were not given through the School Service Commission. Primary to stop. Such appointments were not given through the School Service Commission. And second, No, primary set aside on two grounds. First, comma, as such appointments were not given through the School Service Commission. And second, comma, as they did not have the qualification to be appointed as assistant teachers in secondary schools. Stop. The first ground is not maintainable. The first ground is not sustainable since the act of 1997 was not operative in the hill region after 2003. Stop. The second ground also cannot be urged since all the said teachers have already acquired the training qualification. Stop. Next para. He contends that in respect of the teachers appointed prior to the appointment of the present 313 voluntary teachers, comma, have already been regularized on the rudiments of a policy decision taken by the state. Stop. A perusal of the memo dated 8th March 2019 ট্যাগ করা আছে, তারপর এরকম সাইডে ট্যাগ করা আছে। হলো দেখি কথাটা 8th March, হ্যাঁ। A perusal of the memo dated 8th March 2019 would also reveal that the government took a conscious decision to regularize the appointment of the 313 voluntary teachers and that as such their appointment cannot be set aside as illegal appointments. Stop. Next one. Mr. Bhattacharjee, learned senior advocate, appearing for the writ petitioners, submits that the initial appointment of the said 313 voluntary teachers to post without recourse to the rules of recruitment is not an appointment to a service. Stop. Such teachers have no right to regular appointment, and any such direction would reinvigorate a class of claims which has been shut out permanently. Stop. The appointment of such teachers is also not supported with any final approval of the state. Stop. All such appointments were made in derogation to the decision contained in the memo dated 30th July 2010 of the Secretary, Education Department of DGHC. Stop. No advertisement was issued and no recruitment procedure was followed to engage the said teachers. Stop. A menace of corruption has accorded the undeserved with an unfair advantage over the deserved and deepened the societal chasm between the haves and the have-nots. And as such, any protection granted would only be a grant of premium to an illegality. Stop. In view thereof, the learned single judge had rightly interfered with such backdoor appointment. Stop. Next, Mr. Sinha, learned advocate appearing for the appellants in MAT 10 একটু লিস্টটা দেখাও তো লিস্টটা ও না মিস্টার সিনহা তার আগেতেও মিস্টার দত্ত লার্নেড অ্যাডভোকেট জেনারেল অ্যাপিয়ারিং ফর দি স্টেট ওই লিস্টে ওই দেখো না ওই একটা একজন নাম আছে তিনটে থাকার কথা ও হ্যাঁ ওটা আমি দিচ্ছি এখানে কি লিখলে Mr. Dotto Lanet, Advocate General appearing for the state, argues that the writ petitioners had no locus standi to prefer the writ petition. Stop. The memo dated 8th March 2019 was an in principle, ওইটাকে italics দিয়ে দেবে in dash principle approval awaiting final approval. Stop. Various orders various orders have been passed by the courts directing appointment of voluntary teachers similarly situated with the 313 voluntary teachers. Stop. Such appointments have also been challenged. But such decision may not be set at naught in collateral proceedings. Stop. Mr. Sinha, learned advocate appearing for the appellants in MAT 106 of 2025 argues that the appellants preferred an application being CAN 6 of 2025 in connection with the writ petition being WPA 1089 of 2023, urging an issue of maintainability of the writ petition. Stop. By an order dated 2nd December 2025, the court refused to decide the issue of maintainability at the threshold, and kept the same open to be decided at the time of final hearing of the writ petitions. Asking the parties, continuation, asking the parties to exchange their evidence. Stop. However, the impugned judgment dated 17 December 2025 was delivered, setting aside the memo dated 8 March 2019, leaving the other issues open to be decided in the pending writ petitions. The final relief, a final relief had accordingly been granted at an interim stage. Next. We have heard the learned advocates appearing for the respective parties and considered the materials on record. Stop. Indisputably, prior to the appointment of the 313 voluntary teachers, about 100 teachers similarly situated with them were granted appointment on the basis of the orders of court. আরেকটা লাইন ঢুকিয়ে দিও, মিস্টার ডক্টর পাত্রল, having heard Dr. Patrul, learned advocate, has entered appearance on behalf of the School Service Commission, and Miss Bhattacharjee, Koeli Bhattacharjee, learned advocate, has Miss Dr. Patrul has entered appearance on behalf of the commission, and Miss Koeli Bhattacharjee, learned advocate, has entered appearance on behalf of the board. Next, তারপর যেখানে লিখছিলে সেখানে চলে যাবে, indisputably যেটা on the basic, last wordটা কি লিখলে? On the basis of the orders of the court.
Voluntary teachers, about 100 teachers similarly situated with them and granted appointment on the basis of the orders of court.
Stop. Orders of court. And about 439 teachers were approved on the basis of a cabinet decision. Stop. The validity of such appointment, has also been questioned in the writ petitions. Stop. As the memo dated 8th March 2019, containing a decision to regularize the appointment of 313 voluntary teachers, has been set aside, prima facie, the issue of maintainability of the writ petitions and the issue of validity of the appointment of the other teachers may not survive for any decision in the writ petitions kept pending. Stop. Stop. The judgment impugned, the judgment delivered would have a dissimilar effect, dissimilar impact upon the prior appointments and may lead to an anomalous situation in future. ANAMOLOUS. In future. Stop. The collation of facts put together prima facie reveals that the 313 teachers have been 313 teachers had already rendered a long period of service, and the alleged irregularities in such appointment are bereft of malicious intent or corrupt practices. The learned single judge appears to have focused too rigidly on their initial terms of engagement, on their initial terms of appointment, ignoring the substantive reality of the prevailing political unrest and suspension of operation of the 1997 Act. For the reasons discussed above, the operation of the impugned judgment is stayed for a period of 12 weeks. Stop. The parties are also directed to exchange their evidence in the connected applications within a period of 4 weeks after vacation. Stop. List the matter for liberty to mention after 6 weeks. No. বলে দিচ্ছি কি লিখলে? For a period of 4 weeks. Within a period of 4 weeks after vacation. Stop. List the matter thereafter for further consideration before the next available circuit bench. এবার তোমাকে সাজিয়ে নিতে হবে অনেকগুলো আছে এই পাতাটা না এগুলো একটু কাটতে রাবার দিয়ে মুছে দিতে হবে ওটা আছে আর এইটা
একটু আসতে একটু বলো না কেউ কি মানে কোথায় গেছি লগইন দেখাচ্ছে কিন্তু কথা বললে বোঝা দেখা যাবে গ্যালারি ছবিটা দেখানো শুরু হয় ইংলিশ সময় দেখানো শুরু হয়
Lordship, is it item number 7, Lordship?
Item number 6.
Lordship, in item number 6, learned AG Mr. Amol Sen will appear virtually, Lordship.
The 6 আমাদের
Well, in 6, my lord, I appear, my lord, for the appellant state.
Who is for the writ petition?
But I appear for the
Vikas
petition. I am led by Mr. Bhattacharya.
Hello, good morning.
Possibly Mr. Bhattacharya is trying to enter into the room, lad, online.
He has been added.
Yes, Mr. Dutta.
My lord, my lord, this matter, my lord, pertains to my lord an excise license. Now, my lord, the writ petition is against my lord an order of suspension of the excise license for a period of 90 days. My lord, there were certain, my lord, allegations against, my lord, the writ petitioners, namely, my lord, number one, my lord, that they were performing live band or live music without a license, my lord, under Rule 239. This is the first allegation. Second allegation is non-maintenance of records, I mean accounts. Third is, my lord, storage at an inappropriate place. Fourth is shortage and excess of, my lord, liquor. And fifth was addition and alteration of the licensed premises. So these were, my lord, the 5-4 allegations. My lord, a show cause notice was given. They have admitted all the 5 allegations. Then, my lord, a hearing was given, and, my lord, the license has been suspended for the period of 90 days. Challenging that, my lord, the writ petition has been filed. My lord, one of our preliminary points taken was that this is an appealable order, and from appeal, my lord, there is a scope for revision also. Now, this point was taken, and, my lord, noting the points, my lord, your lordship now may kindly take, my lord, the order under appeal for consideration. My lord, it's at page 66, my lord, of the stay application.
Yes.
But I place from, my lord, the second paragraph. The matter relates to non-compliance of Rule 239 as amended at the license.
Just 1 second, Mr. Dutt.
I'm sorry.
এই বইটা বের করো, এক্সাইজের এই রুলসটা বের করো। ওয়েস্ট বেঙ্গল এক্সাইজ ফরেন লিকার, জাস্ট একটু দেখো যে ফরেন লিকার রুলসটা আছে। ইয়েস, মিস্টার দত্ত।
I was placing, my lord, the second paragraph. The matter relates to non-compliance of Rule 239 of the foreign liquor rules at the licensed premises of Glenary's restaurant cum bar. Apart from the above, it appears that there are certain other violations. The petitioner was heard, and the license of Glenary's has been directed to be suspended for a period of 90 days from the date of receipt of the order. The petitioner is aggrieved. It has been submitted that the restaurant is in operation for more than 150 years. Application under Rule 239 made by the petitioner for the previous year was not disposed of by the authority, and none restrained the petitioner from running the business. It has been contended that the respondent authority with malafide intention suspended the license during the Christmas festival, resulting in huge financial loss to the petitioner. Prayer has been made to direct the authority to permit the petitioner to run the restaurant cum bar, subject to the result of the writ petition. According to the state, the order is an appealable one, and that the petitioner ought to approach the appellate forum instead of filing the writ petition. It has been argued by the state that the petitioner would be bound to suffer the consequences for the offences committed. I have heard the submissions made on behalf of the parties. There is nothing on record to suggest that the application under Rule 239 of the current financial year was made by the petitioner. According to the petitioner, the license ought not to have been suspended, as the application for grant of license under Rule 239 of the rules for the previous year was not disposed of, and the same remained pending. On a perusal of the reply to the show cause notice annexed to the writ petition, it appears that the writ petitioner admits certain allegations, admits certain irregularities. As quite a few of the irregularities pointed out appears to be curable, accordingly, the hearing of the writ petition is adjourned. In the meantime, curable defects shall be rectified. It will be open to the authorities to visit the restaurant cum bar premises for inspection. It will also be open to the authorities to call for records to verify the accounts which were found to be inaccurate. Inspection report shall be placed before this court on the returnable date. Fresh application seeking permission under Rule 239 may be filed by the petitioner for the current financial year if the same has not been filed till date. Now, my lord, against this, my lord, we have come up before your lordship, my lord, Now, please take me at page 56. Three documents where I'll place before my lords. Please take me at page number 56, which is the show cause notice.
Why you are agreed, Mr. Dotto?
Well, this is a Millard, appealable order, Millard. But I
Court has exercised, court's discretion which has been exercised, it has only said that they would be remedying the curable defects and you
yes,
call for a.
yes. That's what Millard I intend to Millard submit before your lordship Millard, whether Millard the defects are at all curable or not. Please have a look to the show cause notice and their reply. Millard, if I falsify my accounts, it cannot be a curable defect. How can it be cured? If there is shortage, it cannot be cured. Kindly consider whether at all these are curable or not. Where the petitioner submits that these are curable defects.
Page 63.
Millard, the first one is page number 56.
Yes.
Millard, first paragraph speaks of the inspection. Please take, Millard, the heading irregularities. Under the irregularities, number one is non-maintenance of registered accurate accounts, non-attestation of accounts by the licensee or authorized representative in violation of so-and-so. Then holding performance, entertainment, dance, live band without written permission. 3 is shortage of foreign liquor at an unauthorized premises in violation of so-and-so. Any other irregularities during the inspection, it was observed that a godown used for storing liquor was found at an unauthorized location. The licensee failed to produce the approved blueprint plan indicating the said liquor godown as part of the licensed premises. During the inspection conducted by the inspecting officers, it was found that an unauthorized storage area associated with licensed premises contained certain discrepancies in liquor stock. Specifically, excess quantity was detected comprising of so-and-so, so-and-so, so-and-so. Additionally, shortage was observed in the stock records, including one bottle, etc., etc. These findings indicate presence of both excess and shortage of various alcoholic beverages stored in an unauthorized location connected to the licensed premises in contravention of the relevant excise laws and licensing conditions. 3. Scrutiny of the approved blueprint plan revealed that additions and alterations has been made to the licensed premises without obtaining prior approval of the collector. Now, kindly signal the reply, which your lordships would find out on the next page, that is page 58. First is, Millard, paragraph number 1 regarding music at Glenaries. You are correct that we have music playing in our restaurant. We have applied for permission last year as required, and the approval was typed and signed by the superintendent. Unfortunately, for reasons beyond our understanding, the signed permission did not reach your office. We have a copy of the approval on record and have followed up several times, but the issue remained unresolved. We have applied again for the current year and we are hopeful for a positive outcome. This is made so far as live band is concerned. Now, kindly take paragraph number 2 concerning bookkeeping discrepancies. We acknowledge that there was an error occurred in the issue and receipt records, mainly because multiple staff members handled them during the main bookkeeper's absence. The gin figures appear unusual, but the difference between the two beer brands from 4 cases offsets one another. It is an oversight and not an intentional lapse, and we will take steps to ensure tighter control going forward. Then 3 is liquor storage area. The liquor storage area has remained unchanged for decades. There has been no expansion or alteration as the arrangement has been consistent over the years and has not been questioned previously. We do not have any formal drawing on the file. However, we will be happy to provide one if required. Then bar alteration. The minor shift of the bar occurred during the COVID-19 when Glenaries was repurposed as a COVID care facility. The bar was shifted by approximately 8 feet and old staircase reopened for ease of movement. The plan was not updated at that time. We have been regularly putting the old drawings for the last 5 years to your office where no objection has been mentioned.
Court will consider that, Mr. Dotto. Court will consider that. Court
Yes,
court has made the matter returnable. Court
my lord,
has kept in
my lord, my first submission would be now.
that
Please,
these are
one more
not.
document.
Yes,
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 yes.
yes.
This is not available.
Yes, Mr.
Well,
Dotto, you
one
wanted.
document.
কি বলছে কি তোমার ট্রান্সমিশন গন্ডগোল হচ্ছে?
My lord, then I like this. Would find it at 60.
Your line is not functioning, Mr. Dotto.
But
We are functioning.
Still, I'm not functioning.
Yes, yes.
Now,
Yes,
please take note page number 60. But at page 60, my lord, first paragraph is, my lord, quoting, my lord, the allegations. Then please take note the fourth paragraph, starting with the relevant inspection report. My lords are found, my lord?
page
Page
60.
6.
Yes,
Please.
yes.
Page 6. Where towards the end of that page, there is a paragraph starting the relevant inspection report.
Yes, yes.
The relevant inspection report initiated and concluded on so and other relevant records, including videographic evidence, were duly examined. Also heard the verbal submissions of Mr. So and so. The irregularities, as mentioned from serial number 1 to 5 mentioned, are in violation of the extent excise law rules as mentioned below. But then when irregularities are quoted, then skipping over the quoted portion, please come to the next page. Mr. A.L. Edwards, licensee of the Glenary, both in his written as well as verbal submission, admitted that live band music performance were conducted at both main bar and the additional bar without obtaining mandatory written approval. From the written submission of the licensee, it is clear that the licensee is aware about the rules that require requisite permission from the collector. It is further informed by the deputy excise collector and admitted by the licensee at the time of hearing that such unauthorized performance had continued till date even after initiation of the miss case. The conduct demonstrates deliberate, intentional, and persistent non-compliance, indicating that the licensee is willfully and consciously involved in conducting such unauthorized live band performances, despite being fully aware of the relevant excise rules and ongoing miscellaneous case proceeding. The licensee also admitted that no fresh application seeking approval for live band for the current financial year has been submitted to the collector as required under 239. Considering all aspects of the case and number of irregularities violations detected in the licensed premises, the gravity of the irregularities violation, the lackadaisical approach of the licensee in maintaining documents, books, accounts, and the whimsical and nonchalant approach of the licensee towards running the license, willful and rampant violation of the rules and laws by the licensee render the license liable for suspension as per the provisions of section 42, hence in terms of so and so suspended for 90 days. Well, my first respectful submission would be, my lord, first is, my lord, none of these, my lord, violations in my very respectful submission is curable in nature.
They can suspend. Definitely less than 90 also. Maximum period they can put under suspend. তো কতটা করা যেতে পারে সাসপেনশন? এটা
My lord, if
yes, কম করতে বাধ্য করে এটাকে।
my lord, if
করা দরকার ছিল। জিজ্ঞেস করে দেখলাম। Yes, Mr. Advocate General, what is the
Yes, my
maximum period of, what is the maximum period of suspension which you can?
my lord, here, my lord, here, my lord, we have as a temporary measure suspended it for 90 days only.
No, what is the
Well,
period you can do? Maximum period.
My lord, maximum period is not provided in the statute, but we have not taken the harshest step to, my
No, you
lord.
see, 90 days is also not a very small period. It is also, you see, 90 days. You see, so many seasons, you see. So it can be lesser also.
No, it can be lesser,
So,
definitely.
no, assuming
Why not
if
lesser?
you are correct.
Yes,
Assuming
yes.
you are correct,
It can be lesser also.
also.
Right, right. No doubt about that. No doubt about that. But the question is, my lord, if your lordship may kindly consider one thing, my lord, in an admitted case, my lord, where there is no dispute that we have a power to suspend, Milord, whether Milord suspension for 90 days could be a ground for invoking the writ jurisdiction in the presence of, Milord, a alternative remedy available to the petitioners. Now, please have a look to the alternative remedy. There are twofold remedies available to my learned friend's client. If your lordships are having the Bengal Excise Act, kindly have a look to
Yeah,
section 8.
one more question, Mr. Dotto, that
Yes.
page 52,
Yes, my
pertaining
lord.
to the earlier application for license,
Yes, my lord.
there was a report of the superintendent on the subject to the following conditions, it was granted. Now
Well, that-
2024 application has not been disposed of as yet. Now we are in
Yes.
2025. So the
Right.
single judge has only said that this ought not to have been suspended. You remove the defects and come back to me. I will look into it.
Yes. Yes.
So
Now,
what
the
is
question
the...
is, yes. Now, please consider, Milord, number one is, Milord, without Milord commenting on, Milord, our contention that this is an appealable order, Milord, could, Milord, the writ court, Milord, pass certain directions to cure the defects? Number one.
No, that is in the context of the present situation. We are in a festive season, and the shop has a reputation of more than 150 years. These are considerations on the basis of
The
which
shop
my
is
lord
not
has...
closed. Milord, this is,
No, no,
Milord, something.
right. We
Shop is,
understand.
yes,
So
only bar cannot operate. Bar cannot operate. The other business is going to run.
you go and tell the judge, you go and tell the learned judge that this bar, we are removing all obstacles, but this bar should not be reopened.
No, Milord,
Let the court answer.
On the last occasion, yesterday, Milord, the court was of the view that the suspension order should be suspended by the court for a limited period so that people can enjoy it during the vacation. I mean, during
Yes.
the festive season. But that possibly, Milord, in my very respectful submission, not a relevant consideration. Kindly do not take me amiss. But if I have exercised my power wrongly,
No, why
definitely,
should
Milord,
we take you amiss? You are not you are not the licensing authority.
right.
Yes.
If my action is flawed, the court will definitely interfere. But Milord, without Milord finding any, without returning any finding that Milord, my action is erroneous, contrary to the rules. And Milord, the exceptions that your lordships have carved out in entertaining writ petition despite availability of alternative remedy, these not being there, but could your lordship will kindly consider whether at all the writ petition could have been entertained, Milord, without disposing of my objection as to the maintainability of the writ petition. But I can understand, Milord, the Honorable Judge, Milord, overrules my objection. That can be done. The learned judge may feel that my objection is not meritorious objection, it can be overruled. Now, without Milord disposing of this point of mine, with respect, Milord, entertaining the
This
writ
cannot be
petition,
done.
this cannot be done. But please have a look to this two provisions, Milord, section 8, Milord, if your lordships are having, Milord, the Bengal Excise Act.
Section 8.
Yes, Milord. But this is a complete code by itself.
Page, USC 12. of Bengal Excise Act.
Milord, I was referring to section 8.
8. Acha. This is control, appeal, and revision. Yes.
In doing anything or taking any action under this act, the collector shall subject to the control of the excise commissioner and of the state government, and in such matters as the state government may direct also of the commissioner of the division, and the excise commissioner shall be subject to the control of so and so. Then subsection 2, orders passed under this act or under any rule made hereunder shall be appealable in such cases to such authorities and under such procedure as may be prescribed by the rules made under section 85, subsection 2, clause C. Then 3, the state government may revise any order passed by the collector, excise commissioner, or the commissioner of a division, or by any officer exercising powers of an appellate authority under any rule made under section 85 of such and such. Now, Milord, so far as my powers are concerned, please have a look to Milord, section 42 of the same act. This power, Milord, I have exercised in this case.
Yes.
There is a power to cancel or suspend, subject to other restrictions as the state government may prescribe by rules made under section 85, subsection 2, clause I. The authority who granted any license, permit, or pass under this act may cancel or suspend it. We're skipping over A and B. Please take C. In the event of any breach by the holder thereof, or by any of his servants, or by anyone acting on his behalf with his express or implied permission, or of any of the terms and conditions thereof. Well, the other conditions, but I'm not reading for the time being because these are not applicable. Therefore, a 42(1)(c) is the power which I have exercised.
সে তো ট্রাই করে বলেই দিয়েছে গভর্নমেন্ট অথরিটি বেরিয়েছে আমাদের কোর্ট উইল ডিসাইড ইট কোর্ট উইল সো দ্যাট কোর্ট তো
Now, Milord, I do not say that, Milord, in spite of, Milord, section 8, the writ court cannot entertain the writ petition. I
Yes,
do not say for
your
a moment.
argument is that the riders carved out for interference in spite of availability of an alternative remedy has
Yes.
has been fulfilled in this case. Opportunity of hearing was granted.
Right.
Inspection was conducted. Irregularities which are non-curable in nature prima facie.
Yes,
In
ma'am.
the said backdrop, this writ petition itself was not maintainable. That is
Right.
your
Milord,
submission.
yes, but the honorable court, Milord, ought to have relegated the parties to the before the appellate authority. But I will not burden your lordships with judgments. But only one submission is that, Milord, trading in liquor is not a fundamental right. Therefore, Milord, we don't fall under that exception also.
Yes.
And Milord, this is not that we have taken the harshest of step by, Milord, cancelling the license. Milord, in the garb or in the backdrop of admitted allegations, Milord, we have merely suspended it for 90 days. Now, Milord, this discretion, whether it should be 9 days or 90 days or 180 days, Milord, this play in the joints, Milord, has to be, Milord, given to, Milord. Your lordships have always allowed this in favor of the authorities, well, unless it is palpably malafide. Well, I can understand, Milord, suspension has been imposed as a permanent measure.
No,
Then,
Mr.
Milord, your
Dotto, Mr. Dotto, the suspension order which you have filed has been found due to this festive season. It is not that the court has thrown away your order of suspension. Court has said,
Yes.
all right, come with a report, let me consider that. After vacation matter will be heard maybe. So what is the impending danger in such a proposal? That today if there is a fire risk or there is a possibility of interference or showing inconvenience to the public, these issues are not there in your show cause. Your show cause only
Yes.
says that you have not corrected the records, your building plan is not proper, and your storing of liquor is not as per the standards laid down under the statute. This can always be considered, Mr. Dotto. But why do you, your prayer has not been rejected. Court may hold that yes, you now these issues are there, these are disputed questions which you need to address in a statutory forum as provided under the exercise. So, Mr. Dotto, why you are insisting
Milord,
for
my respectful response is, Milord, But if my objection is correct, then my lord, no direction can be passed.
I see.
But my lord, the learned single judge ought to have rejected my contention that no appeal is not a bar. But I can understand that.
All right.
Where the court notes it, but with respect, the point is not dealt with. Your lordships, initially,
Yes.
but in a case of this nature, your lordships,
Yes.
generally, generally, first disposes of the point of demur. Then, if your lordships find that there is no substance in the point of demur, then the entire thing is open before the court. But so long as my point of demur is not considered or disposed of, in my very respectful submission, the court ought not to go into the other matters. And the last of my submission is, with respect, none of these are curable. Because if I falsify my account, please consider how can I cure it? But if there is an excess or shortage of stock, I cannot cure it. I cannot put it back on that day. But today, removing the stock or putting the short or the lesser bottles back will not cure the defect which was found on the day it was detected.
All right.
In my very respectful submission, in an alteration of as they call the blueprint, some alterations beyond the blueprint, this cannot be cured.
All
But
right.
these are not normally as we find under the contractual domain, remedying the breach. This principle possibly in my very respectful submission would not apply where in a relationship between a licensor and the licensor means the state statutory authority license and the licensee.
All right.
Therefore, my respectful submission is made. The lordships may kindly stay the operation of the order and decide the point of maintainability. I don't mind the matter point being disposed of this way or that way, but it need to be addressed by the court. But these are my submissions.
Thank you, Mr. Dutt. Yes, Mr. Bhattacharya.
My fundamental point, this is not an appealable order. Under clause 15, without the appeal, intercourt appeal lies only when the first court had decided something. My lord is repeatedly asking this question. The learned first court did not decide anything, which could not make state aggrieved. Now, in this background, Lord, I am constrained to say that this is a malice on the part of the state. Within 24 hours, an appeal I have never seen filed by the state against Lord, suspension of a bar license. Now, I am not going to the background. And secondly, my lord, I have cited the Supreme Court judgment. I would cite without when my application under 239, Lord, I was penalized because of violation of 239, not for the discrepancies. Kindly read the order. That you are still performing, therefore you are violating 239. I impose penalty. 239 is the permission for live band performance. Now, the live band performance application was there. They had granted the permission. My renewal application was there.
My lord, page number 334. Can you have the book? Yes, 334.
No, what are you arguing, Mr. Bhattacharya? Under 239.
I am saying that the rule 239 permission was granted by them for 2003-2004. That is a part of record. 2004-5, we had made the renewal application.
Sir, 23.
23.
Now, this application was not disposed of. Now, the Supreme Court is very categorical. They have no right to
Mr. Bhattacharya, we didn't follow. Your 2023 permission was granted.
23
permission, year 2023 to 24 was granted. 24 was
granted.
And on the basis of the 24 application, this order has come out. This is on the basis of
24-25 application was kept pending. Now they proceed against me that you do not have 239 license, therefore you are violating law.
2024 application was not processed.
Not processed in the midway, but final decision was not made known to me. That is, my lord,
Then-
the record your lordship kindly come to the, my lord, the documents which was placed. That's why the learned judge had been pleased to record this. Now, while this application was kept pending,
Where is
Lord,
that
my
recording?
Lord, kindly come to, my lord, the order passed by the learned judge. It records
Application.
that
Yes, paragraph 5.
6 of 5 and 6
Yes, so, all
has
right.
been done with a malafide intention. Now, my lord, I relied upon
Now, why
the
you are
Supreme
saying
Court
this is,
judgment 1990.
why you are saying, Mr. Bhattacharya, this is not an appellable order? That
Because nothing has been decided by the first
Read court order is not
Reed
appellable.
Court did not decide anything.
Yes.
Yeah, that's my point.
Yes.
I am not, my lord, on statutory appeal. That's a, my lord, frivolous point, if I may say so. My lord was repeatedly asking, my lord, that alternative remedy is no remedy to me in the background of the fact situation. I have to go to the appellate authority, then revision, 90 days in the meantime would be over. Therefore, that is not an effective remedy for me. My remedy only lies with the, my lord, Reed Court challenging the action of the state authorities, which was not a bona fide action.
Yes.
Now, my lord will be pleased to see that the excise license categorically says that they can impose penalty for even monetary penalty. Kindly come to me that my license, which is annexed.
No,
The question which was put by the Honorable Judge, Justice Chaudhary, that the license, my lord, says, I am reading out from the license, the excise license,
Page?
infraction of any of the above, no, that is, might be page 26.
26.
26 of the writ petition.
Here, page 43, Mr. Bhattacharya.
43. I am thankful to Mr. Advocate General. NB, infraction of any of the above conditions of the general conditions applicable to excise license or of any provisions of the Bengal Excise Act or any rules orders made under the Act or of any special order made in respect of the license by the competent authority will subject the license to cancellation, suspension, or will subject to the holder of the license such cancellation, suspension, pay penalties prescribed by the Act or the rules for the time being in force.
No, this is not for the
Now,
live band.
now
this is not for the live band.
This is for
the
no,
liquor.
no, live band. This is for the yes, Lord, I have been suspended, Lord, with this, Lord, liquor license now.
No,
Lord, I would have appreciated the live band is suspended. I have quarrel. I may not have live band. But
No.
here the suspension is of my excise license.
Oh, I see.
The suspension is, my lord, the excise license. That's the line that the judge was concerned that if there are curable defects, let it be cured. And the others, the
this is valid, I think, till 2026. It is 31/3/2026.
Yes.
So this license has been suspended by the order impugned.
Yes.
Yes.
Now, my lord, in my humble submission, the cancellation was really prompted by not having 239 license. Now, I just rely upon one Supreme Court judgment, though your lordship need not go into this at this stage. This is 1991 supplementary to Supreme Court cases, page 647. The Supreme
Esha,
Court
please
says
hand over.
that you cannot proceed when the license application was kept pending. But
no, Mr. Bhattacharya, they are
paragraph 4.
While suspending the license, they have also observed about this live band which is being operated by you without permission.
That is the basic concern for the suspension, not below the discrepancies. If a lordship go through the order, I'm just reading out.
Please answer our query. If for this live band, Did you ever have any permission?
Yes.
Where is that page?
Will kindly come to read page 26.
26 is the,
No, sorry,
this is
sorry,
the
sorry.
liquor license.
Sorry, well, kindly permit me. Additional bar, then this is 2003 license. Is that page? So
That
kindly
page,
come
my
to
lad,
the
52 first.
52.
They have just
no.
now sent the paginated copy. That's why.
Oh, page 52 of the appellate.
So you made an application for live band on 10th of April 2023.
That was granted.
Oh, this was granted any time period?
Yes,
Or
it is done for a year.
where is that order?
Look, the license itself shows.
Sir, আমি বলে দেবো? Page
Yes, kindly come to
50.
page 35. I do not know corresponding page.
43.
Yes,
On
52.
10th of April 2023, the Superintendent Excise grants me permission under Rule 239 of the West Bengal's Excise Foreign Liquor Rules 1998 as amended. On the basis of the application dated 28 March 23, you are hereby granted permission under Rule 239 up to 31st of March 2024, 1 year permission. And Lord, before expiry of this, I had applied. That application was kept pending. And in fact, Lord, the inspection was also carried out for grant of permission. But something has happened in the meantime, the permission was granted. Neither refused, nothing done. In this background, Lord, I relied upon the Supreme Court judgment. The learned judge was going to consider that what has happened, how does the state is, Lord, suffering from this order? Learned judge has not yet said that the alternative remedy available, I have to go or it's not available. That will be considered by the judge. At this stage, how come the appeal court comes into the picture? What the appeal court will decide?
Yes, thank
These
you.
are my submission, madam.
Thank you. The present appeal has been preferred.
But could I make a short reply subject to your lordship's permission?
Yes, Mr. Dotto.
But the first point is malice because appeal preferred within 24 hours. Well, neither here or there. But the second is the rule 239 application for the previous year was not disposed of. This is the second argument. But with respect, my lord, if an application is not disposed of, my lord, the remedies are with the petitioners to approach the appropriate forum. The remedy is not by way of violation. Somebody cannot violate and come and say that why have you not disposed of my application, therefore I violated. This is the precise submission. The other aspect of the matter is, assuming that there was some delay on the part of the authorities
No, Mr. Dotto, your order which has been impugned before the writ court, that is an order refusing the license for liquor also.
That is, my lord, it is not a refusal, my lord, it is a suspension of a license. There are 5 allegations. One of the allegation is that you are doing it without a 239 license. Now, my lord, 239 license, my learned friend Mr. Bhattacharya says that the state has not disposed of their application under for a license under 239. Assuming that to be correct, today they don't have any application also pending for the present year. But I can understand, they are speaking of the previous year where they have allegedly made an application and we are sleeping over it. But this year, they have not made any application which the learned judge has permitted. In the order under appeal, your lordship,
that has been permitted.
Judge has permitted. Therefore, the allegation of non-consideration, the allegation of sleeping over their application, at the most can be of the previous year, not of this year. And it goes without saying.
Continuous inaction. Anyway, without
in their knowledge.
But this is a each year permission, therefore it cannot be a overlapping inaction. If there was an inaction, it was inaction for the past year, not for this year because they have not applied. The other is that Mr. Bhattacharya says that why suspension, you could have imposed monetary penalty. Now, but this discretion is not subject to judicial review.
Yes, yes, if you, that's the Supreme Court judgment. If Mr. Datto wants me
It
to
doesn't say. But I
Supreme
can
Court
understand,
says-
I can understand, Milord, his license has been cancelled. These
The-
questions may arise.
Mr.
But
Datto
I
will
am
explain this. Supreme
I
Court has
am
made it very
fundamentally
clear.
on 2
Even
points.
anyway,
Milord, at the end, my learned friend says that the point of appeal has not been disposed of today. What is the harm? It can be disposed of at the time of final hearing. And in the meantime, Milord, if an interim order is passed, because yesterday the learned judge said that I'm going to stay for 15 days, the suspension order. Everybody has heard it, but I don't need to, Milord, emphasize on that. Therefore, Milord, unless my point is decided, but please consider whether any order, whether it is appealable, not appealable, but I respectfully submit, as per Shah Babulal Khimji, Milord, not disposing of my preliminary objection or the demur is again, Milord, an order which is capable of appeal under clause 15 of the latest patent.
All
Because
right.
it agree with me. Wait, these are my submissions.
Thank you. The present appeal has been preferred, challenging an order dated 17th of December 2025, passed by the learned single judge in the writ petition being WPA number 2505 of 2025. Which was preferred. Challenging inter alia an order dated 4th December 2025, passed by the Additional District Magistrate bracket capital G and Collector of Excise, Darjeeling, in Miss Case number, page 38 numberটা দেওয়া আছে 04/2026/07958/F. Records would reveal that the writ petitioner
Well, would your lordships permit me to log out, Milord? I'm so sorry.
oh, so we
Today is the
will
last
log
day.
out. We will log out from your atmosphere. Yes.
Today is the last day, Lokhi Pujo day. Please don't forget.
Yes, you may go now. Mr.
I am
Seth
grateful.
will be there.
I am grateful.
Records would reveal that the writ petitioner, a proprietor of the Glenaries restaurant cum bar, was granted a license for Mr. Shamim, what is page 43? This I cannot read. License for the
Page 43.
this is what is the license for the
Just a second, 43. 43 is the license for the operating the bar.
was granted a license for কি বলেছে এটা right in the license for
Sale of foreign liquor for consumption.
for
Foreign
what?
liquor for
Foreign-
consumption
Ah,
on the
What
on
is
the-
the fourth word? License for
Retail sale of foreign liquor for consumption on the
License for
premises
retail
of any
sale
restaurant and
of
attached
foreign
bar.
liquor for consumption on the premises of any restaurant and attached bar. Vide memo dated what is the date of this? For license for the bar for the period from 1st April 2025 to
10th April 2025.
Vide memo dated. Where do you find?
At the bottom, lad.
সেটাই bottom the date of the oh, 10/4 VDA memo date granted such and such license VDA memo dated 10th April 2025 stating inter alia that the said license shall remain valid for the period from 1st April 25 to 31st March 2025. Stop.
2026.
2026. Stop. Stop. The writ petitioner also applied for sanction to hold professional entertainment or to permit playing of vocal or instrumental music. Such prayer, the said upon consideration of the said application, permission was granted with a memo dated 10th April 2023 under Rule 239 of the West Bengal Excise bracket FL bracket close rules, 1998 bracket page 52 করে রেখো। This was for what period?
Well, up to 31st of March 2024.
Where do we find that? Up to 31st of March 2024. Stop. An application for renewal was thereafter filed by the writ petitioner, but the same was not disposed of. In the midst thereof, the impugned order dated 4th December 2025 was passed, suspending the license of Glenary's restaurant cum bar for a period of 90 days. So Mr. Dotto, learned Advocate General, assisted by Mr. Sen, learned Additional Advocate General, submits that the writ petition itself was not maintainable. In view of the provisions, in view of the alternative remedies provided under the provisions of the Bengal Excise Act 1909. Stop. Such issue as urged was glossed over and no finding was returned on the same. Stop. Mr. Dotto further argues such fine alternative কি বলেছো such and West Bengal না such issue as ওটা পরে লিখবে তার আগে লিখো the riders carved out for entertaining a writ petition. The riders carved out for entertaining a writ petition in spite of availability of alternative remedy also do not apply in the present case, since the order impugned was passed upon granting an opportunity of hearing, and there had in fact been no infringement of any enforceable right. Enforceable. In such argument as urged was glossed over by the learned single judge, and no finding was returned on the same. Stop. Such infirmity warrants interference in the present appeal. He further submits, Mr. Dotto further submits that drawing out, no, further submits এর পরে এরকম লিখবো, drawing our attention to the order impugned dated, drawing our attention to the order impugned, the Mr. Dottu submits that the defects as has been indicated are not curable in nature. And that there had been an admission on the part of the writ petitioner as regards non-compliance of the statutory provisions. In view thereof, the learned single judge ought to have refused to exercise discretion in favor of the writ petitioner. Mr. Bhattacharya, learned senior advocate appearing for the writ petitioner appellant, however, denies and disputes the contention of Mr. Dotto and submits that primarily the present appeal itself is not maintainable, since there had not been any decision on merits of the matter. Merits of the he further contends that the writ petitioner is enjoying the license for retail sale for foreign liquor, as would be explicit from the memo dated 10th April 2025. The permission as initially sought for under Rule 239 of the 98 rules, ওই আগে লিখেছো ওয়েস্ট বেঙ্গল এক্সাইজ FL rules 98 করছে, ওটাকে hereinafter referred to as 98 rules করেছে, হ্যাঁ। 500 কি লিখলে? He further contends ওটা দিয়েছে, তারপর he further contends that the petitioner had also applied for the petition, after the permission that was granted with a memo dated 10th April 2023, the writ petitioner applied for applied for permission afresh, but the same was admittedly not disposed of by the authorities. In the said conspectus,
That was applied for the earlier year.
This page 40.
40 bullet we have made in
Page-
20, yes, in July 2024 possibly.
Where is that? You have made that application?
Yes, I made application in 2024 and again now in 2025 we have also made an application.
No, in
Since
2025.
since previous application was not considered, we did not make any fresh application. After the order of court, we have made again in 2025.
No, 10 after the permission was granted with a memo of 10th April.
But
It
this,
was
yes,
That was for till 31st of March 2024. Thereafter also you filed an application
yes.
which has not been disposed of.
yes,
That
yes,
is
yes,
not-
yes.
No, my
Because
lord, may I
facts
tell
are
one
very
thing?
clear. Let us not get confused with the facts.
No, my lord, the
Facts are very clear.
respondents are confusing. They did apply for the year 24-25, which was, my lord,
We have said
had
that.
it
We have not said
been
anything else.
expired on 31st of March 2025. Then in 2025-2026, my lord, there was no application. It has been recorded in the order impugned of the
Arre,
learned
that was
single
not
judge.
considered. The
Now,
pending application is yet, yes,
Let us
pending.
let us
for the
understand.
current
Page,
year, they did apply only after
Mr.
the order
Ore
passed,
Bhagwan,
which is
Mr.
under challenge,
Mr.
which is under challenge.
Mr. Sen,
In the
Mr. Sen,
My
page,
lord, my lord.
page 52 was the permission of 10th April 2023,
My lord.
which was valid up to 31st March 2024.
Grateful lordship,
They filed a fresh application for such license,
my lord.
which was allowed, granting them permission till 31st March 25.
No, yes, had it been allowed,
No,
it was
no.
not
Had it been
allowed.
allowed, all right,
Had
all
it been
right.
allowed, it
That
was
is what
not
we have.
allowed. It
It
was
was
under consideration, but
that is
even
what
had
we
it
have
been allowed,
recorded, Mr. Sen. That is what we have recorded. He made
yes,
an
but so far,
application which has not been disposed of.
yes, but so far the current year, when the
All right,
inspection
current
was
year we
made,
are not going.
there was no application. My
It is one of the changes to the duty that information applied for permission applies, but the same was immediately not disposed of by the authority.
In the said conspectus, the learned single judge, such facts were taken note of while issuing the order impugning the present act. We have heard the learned advocates appearing for the respective parties and considered the materials on record. In the order impugned, the learned single judge upon observing inter alia that the suspension of the license, upon taking into consideration the argument, upon the learned single judge observed that the defects pointed out by the authorities, some of the defects pointed out by the authorities are curable in nature and accordingly directed such curable defects to be rectified. Further observing that it would be open for the authorities to visit the restaurant cum bar premises for inspection, and it would also be open to the authorities to call for the records to verify the accounts, which were found to be inaccurate, which were found stop. And liberty was also granted to the writ petitioner to file fresh application seeking permission under Rule 39. Stop. The learned single judge under Rule 239 and made the matter returnable on 22nd December 2025. The learned single judge observed inter alia that সেটার প্যারাগ্রাফের এই প্যারাটার আগে একটা প্যারা দুটো, এই প্যারাটার আগে আরেকটা প্যারাগ্রাফ ঢুকাও। It was submitted before the learned single judge that the restaurant cum bar is in operation for more than 150 years, and that the authorities ought not to have taken such coercive steps during the during the Christmas festival, resulting in huge financial loss to the writ petitioner. তারপরে ওই প্যারাটা দেখা stop. And the matter was made returnable on 22nd December 2025. it is now well an appellate power interferes not when the order appealed is not right. ও না, এটা দিয়েছে। আচ্ছা, ওই মিস্টার ভট্টাচার্যির আর্গুমেন্টটা যেখানে আছে, ইন সাপোর্ট অফ হিজ আর্গুমেন্টস, মিস্টার ভট্টাচার্যি আর্গুমেন্ট পরে দেবে, রিলায়েন্স হ্যাজ বিন প্লেসড আপন এ জাজমেন্ট ডেলিভার্ড ইন দি কেস অফ মুরারিলাল ঝুনঝুনওয়ালা ভার্সেস স্টেট অফ বিহার অ্যান্ড আদার্স, reported in 1991 supplement to SCC 647. An appellate power interferes not when the order appealed is not right, but only when it is clearly wrong. Clearly wrong. The learned single judge in the order into the learned disclose the reasons towards the observation that the license ought not to have been suspended as the application for grant of license under Rule 239 for the previous year was not disposed of. Stop. The appellate court should not interfere in the exercise of discretion by a learned single judge unless such exercise is palpably perverse. We do not find any such perversity in the order impugned in the present appeal. Accordingly, no that the court will say, no interference is called for in the present appeal. Accordingly, the appeal and the connected application are dismissed. There shall, however, be no order as to cause urgent certified Xerox copy.
Deeply obliged.
Grateful.
এবারে আসতে হবে কি আর কিছু করার নেই। Rising for 5 minutes.
Hey, to local. Give us just 5 minutes time. We are coming back. Order
ওই জলের গ্লাসটা নিয়ে যাও।
Lordship, 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 in item number 7. Lordship, Lordship, in item number 7, I am appearing for the petitioner. Lordship, in this matter, at the stage, petitioner praying for an interim order for stay of auction, which is being last annexed to the stay petition. On the background that, Lordship, without any proceedings under without any declaration under NPA, a proceeding has been initiated under section 14 before the district magistrate Kojvia. In the proceeding, petitioner appeared and he makes a proposal for one-time payment. Then he refused. Thereafter, he moved a writ petition before this honorable court, before my Lord Justice Vishwajit Basu, and wherein his lordship has been pleased to pass an order directing that on the next date of hearing, that is on 20th December 2024, if petitioner makes such payment, the district magistrate will conclude the proceedings accordingly on the basis of said payment. On 20th December 2024, petitioner had been to the office of the district magistrate and made such prayer with the 3 account pay check, but refused to accept. Thereafter, petitioner moved another writ petition before this honorable court. Lordship, am I audible to your lordship? But lordship not audible.
First, show us the order which was first passed in your first writ petition.
Lordship, I am coming to the page 63, 64 of the stay petition.
Yes, place the order.
63, 64. I am placing the order, Lordship. Lordship, shall I read the
No,
ordering
the
portion only or entire order?
third paragraph says bank had initiated a proceeding under section 14. Fourth
Lordship.
paragraph says that you are willing to liquidate the dues. And fifth paragraph says next date is fixed on 20th December. And
Lordship.
it was said that the petitioner would be free to approach the respondent number
Lordship.
1 for payment of his dues. Now,
Lordship.
when did you approach them?
On the very day, 20th December.
Very good. Then what happened?
Then they refused to accept said prayer, said proposal. Thereafter, petitioner moved a further writ petition.
Yes. Where
before
is that?
this honorable court.
Where is
In
that?
the said writ petition, this honorable
Where
court has
is
been
that
pleased-
order?
I'm coming to that. Lordship, that order is page 65, 65 to 73, and
No.
then 74, 75.
Why you
74
are
to
saying
75.
65? First order was page
74, 75.
63. Yes. What is the order now? Learned advocate
74,
bank submits
75.
in
I'm
terms
coming
of
to that
order.
Lordship.
Petitioner has submitted 3 checks covering the entire amount for the banks submitted. He submits that an order be passed directing the page 70.
74, 75, Lordship.
This is a wrong
Lordship, in
recording,
that-
na? How can the learned advocate for the bank say that in terms of that order petitioner has submitted current, he submits that an order be passed directing the DM to hand over the checks with a direction to state has not yet
to
state-
communicate the said order. Till now, no order is communicated. Till now.
Wait. What order? Order was to pass directing the DM to hand over the checks. Now ultimately disposed of by directing the DM to communicate the order passed in section 14.
First of all, they have stated before the
Now that
order
or-
not
Very
not
good. Next,
communicated.
after that you preferred another writ petition.
As a civil
Civil-
another
Civil revision.
civil order, Lordship, under 227.
That is at page 48.
Lordship. Now, in that order, Lordship, kindly come to paragraph 8.
Yes.
The divisional application was dismissed,
Yeah.
but with liberty
To
on the
approach.
basis of the approach.
Now after
And I
that,
made such
After that, they did not do anything. Then you
Did not
preferred-
do anything.
They, huh?
We have planned this thing. Our lordship will find that page 107 of the stay application, our decision that we have not, the amount she is offering is not satisfactory. Page 107.
107. Huh.
This order was, this communication was passed by the bank to him on 5th September 2025.
Thereafter, he preferred another writ petition.
No.
Now-
7th
now-
December,
8 lakh was paid, 8 lakh was
17th
proposed.
December,
your
Total-
order was
total
5th
one-time
September.
payment.
our order was passed on 5th
September.
5th September. Yes. Now
No.
what happened? After this amount, he did not, we have asked him to enhance the amount, he did not. He kept quiet. Lastly, when the sale notice has been issued.
He filed the writ petition.
So how much you claim?
No,
Apart from
Lordship,
this 8
Lordship,
lakh?
kindly come to.
No,
Lordship, kindly
apart
come
from
to.
this 8 lakh,
They
how
have,
much?
there is
As
a,
on date,
No.
as on date, the outstanding amount is rupees 14 lakhs 80,000. This
no,
was
no,
the-
9 lakh something in their auction
No,
notice.
What was, at that point of
Last
time, when he
annexure in
approached,
auction
when he
notice.
approached you, 5th of September,
Yes.
how much was due and payable? He deposited 8 lakh.
Yes, yes, it was informed to him kindly.
Which page?
Extend the amount, but
Page
no
103.
quantum of
Page
amount
103.
noted there.
To enhance the amount.
Yes.
So how much that was not?
I'm coming to your lordship.
Okay.
They have not stated how much to
How much
enhance
I-
Lordship.
It.
Now their demand
I'm
notice
reading
is,
from this
now
letter.
their notice is for rupees 9 lakhs.
I'm
This
reading
this
from-
is the
reading-
I'm reading from his
page
letter.
108.
It appears
page
from the account
100
report, page
Page-
103. The letter starts from page 103.
And I am agreeable to pay this
103.
amount, Lordship,
This-
Just
because it is
letter
my
was sent
residential
by-
house.
Just a
Will
minute,
you
just a
please allow us to hear him? It is very
Lordship.
difficult.
Lordship.
This letter was done by him on 27th August,
That is 105 of this petition.
page 102, and the 11th portion is at page 103.
Yes, page 103.
3, paragraph number 1, it
Paragraph.
appears from the account report dated 18th August 2025, as supplied me on my request, total dues as rupees 9,46,944 as on, yes, misquoted this date. If your lordship takes the sale.
So that 8 lakhs which was given by him, 8,45,000, that amount was not received by you?
No, we have.
You have refused. So now, sir, according to your sale notice, the price is 9,46,944.
What this was calculated up to 30 April 2023.
So why don't you consider, if we enhance the amount from 8 lakhs to the amount which you are claiming?
Yes.
Your claim in the sale notice is 9 lakh. It is his residential house. We cannot force you to do something. We can request our officer. You are our officer.
See, something is done.
If suppose the total is, because interest you will calculate on the basis of compound interest, it will go. But the person that in some cases Supreme Court has interfered, saying that compound rate you need not take. So now we will. Yes.
Account date, outstanding amount of rupees 14,80,000. But if he has to settle the account in terms of simple interest calculation, amount stands at rupees 13 lakhs. Because this amount was on 30/4/2023. This 9,46,944, which have stated in the sale.
No, if simple interest is calculated, how much it comes when
30 lakhs.
when he approached you in the month of September? In the month of September, when he approached you, how much would it have come?
Yes.
No, 9 lakh, it was 2023. Suppose if simple interest is
That
calculated,
means today, as on date, it's 13 lakhs.
but in the month of September, that is after just 2 months ago.
2 months, it will be 12 lakhs 50,000 or something like that.
12 lakh 50,000.
Like, but I have talked to the branch manager of the.
13 lakhs.
13 lakhs in simple interest rate.
No, Mr. Dhar, he's ready with 8,50,000. 8,50,000 you receive, and we will say that if he doesn't pay the remaining amount within such and such, you will proceed with the sale notice. Finished. If you throw him away, that I will not accept. It is because you cannot, this person cannot be saved otherwise. We are just making this because your sale will be on
First level.
December. So we can at least make this observation talking to Mr. Dhar. Your claim is about 13 lakhs as per simple interest. So you are saying tentatively 12.5 lakhs. 12.5 lakhs. Now we will ask him if he is ready and willing to pay that amount, because under the sale notice also, Mr. Dhar, you know that after auction is put, reserve price is indicated. Suppose the highest bidder offers you say 13 lakhs. In that case, the statute itself provides that first ask the borrower whether he is agreeable to pay that amount. If he is agreeable, you take and drop the sale. So we will ask him how much he is to pay. We will record his submission. We will dispose of the matter. Finished. Yes, Mr. Dhar, how much you pay?
Lordship,
12.5 lakhs. You have plus, first listen to us. You already have 8,46,000, 40,000. 8,40,000.
8 lakhs.
You offered
8 lakh 50.
8,50,000, na? You offered
8 lakh 50.
8,50,000 you offered.
Lordship.
So you 8,50,000 you will hand it over to them today. And the remaining amount is 4 lakhs. You pay 4 lakhs prior to 28th.
Lordship, regarding 4 lakhs, Lordship, some time is to be
Specifically
allowed.
instructed by the
Only
branch
10
manager
to
and
15
authorized
days.
officer, they will only settle the account, only nothing less than 30 lakhs. This is that might be.
Mr. Dhar, ask your officer.
Yes,
That
before the matter-
court is simple interest. It is a question of 50,000. You are asking 13, he is giving 12 point.
Before the matter was taken up, 5 minutes ago, I had talked with the branch manager, he specifically said, sir, 13 lakhs, we have at the.
Acha, let us see whether he is agreeable to 12.5 or not. Then we will. Yes, Mr. Dhar.
Lordship, I am agreeable to pay the 12.5 lakh, 50. But for another 4 lakhs, 1 month time may be given. 1 month,
How
only
can
1 month.
suppose after 4 months you do not pay, what happens?
1 month.
No. Then they will continue the proceedings on it.
1 month.
So this sale notice will go. Bank will be incurring further expenses. What are you saying? Nothing can be done in your matter. We will giving you a leverage, and Mr. Dhar is assisting us. Don't bargain with the court.
No, I am not bargaining. I am Lordship,
We
subject
will
to your
only
Lordship.
observe. We will only observe that upon hearing both the parties, the amount upon calculation of simple interest from the date on which he has offered 8,50,000 tentatively comes to 13 lakhs.
Lordship,
But
Lordship.
we are directing payment of 12.5 lakhs. 12.5
Lordship,
lakhs.
12.
12.5 lakh. He will pay 8,60,000 by tomorrow or day after. Today we are on, tomorrow is Christmas. You people will be busy. How will you
By day
collect the
after
money?
tomorrow.
How will you collect the money in Christmas? Huh? So we will say 26th, he will pay 8,50,000 and the remaining 4 lakhs will be paid on the 30th of, when is your sale notice? 31st or 30?
30th December.
30 December.
30th, in the event such payment is made, you will not proceed with the sale notice. Finish. Ashok. Thank you, Mr. Dhar.
I'm grateful, Lordship.
Are learned advocate for the parties. This application is directed against the order passed by learned single judge of this court dated 17th December 2025, by which the learned judge was pleased to dismiss the writ application WPA 2485 of 2025 filed by the appellant with Sri Subroto Singh. The learned single judge was pleased to observe that as the matter cannot be adjudicated by the writ court, the petitioner is to approach the debt recovery tribunal in terms of the Surface Act for redressal of its grievance.
Acha, Mr. Dhar, his land deeds are also with you, na?
Yes. Yes, Lordship, deeds are with them.
আবার কথা বলে, হ্যাঁ?
Ground for this.
No, Mr. Dhar, yeah, once he makes that payment, you return the deed to him. Finish.
That's the document we hand over in-
Right.
for the taking the-
Upon hearing the learned advocates and upon the suggestions given by the parties that they are ready and willing to.
Yes.
I have sent a message to the bank branch manager from here and now. He said, কত দিলে
Proceed with the sale.
Just that, look, look.
Given by the learned advocates for the party
Considering the suggestions.
and upon considering the suggestions given by the learned advocates for the parties, we are of the view,
It is directed as follows.
we are of the view that the following directions should be issued. Number one, the petitioner, Subroto Singho,
Appellant.
the petitioner appellant Subroto Singho shall make payment of rupees 8,50,000 to the
What was 8,50,000 or it was 8,60,000? That bank draft which you gave? Yes, sir.
Should be 8 lakhs, Lordship. 8 lakhs by last payment.
1,90,000 and
Is
6,10,000. 7, 8,
6
oh,
lakh
8
10.
lakh. Okay,
8
make
lakh.
payment of rupees 8.5 lakh
8.5 lakhs by 26/12/2025
to the bank.
to the bank.
Next.
The appellant thereafter shall make the payment balance payment of rupees 4 lakhs on or before 31st December.
No, now where is the sale notice? Date?
That is the last page,
What
Lordship.
is the
100
date? When is
11.
the auction going to be held?
30 December.
100 page, page
30th
108. Lordship.
December.
Page 108. 30th December 20.
Only 29 December. 28 No, sale notice আপনি touch করুন।
Acha, the
Balance
balance
amount.
amount of 4 lakhs shall be paid on or before 30th December.
No, 30th to is the sale.
তার আগে দিতে হবে
29.
before 30th December 2025.
না, specify করে দিন, 28 তারিখ করে দিন। আপনি করতে পারবেন।
আচ্ছা, ওটাকে তাহলে করে দিন shall be paid by 29/12/2025. তারা 29 তারিখের মধ্যে দিয়ে দিচ্ছে 3 দিনের মধ্যে। In the event the payments are made, the
Even the payments as
directed are made, the respondent bank shall settle the dispute and release the appellant writ petitioner and hand over the title deed which is collected.
We write at the very in the event most of the money is not, the bank would be applied at liberty to proceed with this.
In the event the directions are not complied with, the bank authorities are permitted to proceed with the sale.
Yes,
Grateful, Lordship.
disposed of.
Are learned reports for the appellant, the bank authority and the state of West Bengal.
No, as agreed. Mr.
Mr.
Dhar, instead of suggestion, we are saying that as কি লিখেছো?
Agreed.
Agreed. No, the parties. আচ্ছা থাক suggestion. But Mr. Dhar, you see that it is done.
Yes, sir.
And you also do not create any problem. If you go and he's a what? He's a local. Mr. Dhar, be careful. If your client
Lordship,
acts
Lordship.
otherwise.
Lordship, I am
Client
grateful,
acts
Lordship.
otherwise because in surface no jurisdiction is
There is no
existing by
uphold
this
scope.
court.
There
You
is no
also know
scope.
that well. Now,
Lordship,
if your client acts otherwise, feeling to be a very influential person, we know how to deal with your client then.
Lordship,
See
Lordship,
that it is done. Yes.
Lordship, Lordship.
চলো আর কি আছে এই শোনো সুরজিৎ এই কোমল মিত্র না
Lordship, for the appellant.
My lord, I'm appearing for the appellants. May I be permitted to appear?
Mr. Ajay Singhal is appearing for the appellants.
go do it before the next circuit, sir.
My lord, my defect has been cured, my lord, if that could be indicated, my lord. I
আচ্ছা,
had submitted the certified copy.
alright, আচ্ছা আচ্ছা দেখি ফাইলটা দাও item number 8. What is your can 1 section 5?
My lord, stay, my lord. That has been considered, and my lord, I am enjoying an interim order, my lord.
Oh, that is why you are so happy.
Lord, I am.
Then what are you wanting to do?
My lord, I was directed to cure the defects, my lord. I had to submit the impugned order, certified copy of the impugned order, my lord, which I have done, my lord, in the meantime.
The copy is already filed. Simon has been filed, and as such the defect as pointed out stands. Have you filed your opposition to the application? You are for the respondent.
I'm for the.
Have you filed opposition?
I will cancel the application for recall of the order passed.
My lord, they have filed an vacating application, my lord, which I seek to file an opposition to, my lord.
Where is that? That is not here in the list.
My lord, they have filed it yesterday only, my lord.
Oh, you have filed it yesterday.
It's not in the list, my lord.
What was the order under appeal?
My lord, I was not
matter.
my lord, I was not made a party, and behind that an order has been passed, my lord. There was a subsisting interim order which they have suppressed, my lord.
What interim order was subsisting?
My lord, kindly takes the last order, my lord. It has been extensively there, my lord. Kindly takes, my lord, para number 12. My lord found that in the last order, my lord.
Oh,
As
there-
noted herein, while dealing with the application for leave to preferring appeal, we found that there subsisted an order of injunction till 15 days, way beyond the time the impugned order was passed.
What was
Therefore,
the impugned order? What
my
was
lord,
the
my lord, there was an order of injunction wherein the Honorable High Court and subsequently the DRT had passed that the bank and the auction purchaser shall not change the nature, character, and possession of the property. Now, without impleading us as a party and without considering that, without informing the court about all these interim orders, my lord, they have tried to invoke the writ jurisdiction and obtain a execution of sale certificate, my lord. While that was the specific interim order that was granted, and the matter is pending before the learned DRT, my lord.
vacating application? Vacating application stay হয়েছে আর কি vacating application করেছে the same is treated as on basis immediately exchange করতে হবে
Yes, record an order.
Your Lordship, I am for the respondent opposite party, DA3 malls. In this case, we have filed.
Yes, sir.
We have filed CAN 3 2025.
Yes.
That will be hard.
Oh, your junior has told us already. We have taken note of that.
Learned advocate for
So
the.
let it be fixed
learned
in the next
advocate for the appellant and learned advocate.
January.
You are for respondent number 1. Respondent number 1 are present. our learned advocates, as the defect pointed out in the record is already removed, the appeal be regularized. As it is submitted by the learned advocate for the respondent number 1, that an application for vacating being can 3 of 2025 is filed for vacating the interim order passed by this court. Let the said application be treated on the case list. Stop. And let affidavit in opposition.
The plaintiff, the appellant shall.
The appellant is permitted to file affidavit in opposition
To the
within
the
3
vacating
to
application.
the vacating application
Within,
3 weeks after vacation.
no,
Your
Taradari.
lordship, 5th
2 weeks,
January
my
is
lord.
only
My
fixed.
lord, 2 weeks.
There is no
Within a week after the vacation, you
My
file.
lord,
the
2 weeks from
application.
date, my lord.
No, don't make it 2 weeks. You are enjoying an interim order. Let that.
Within 1
My
week
lord, from
of
date,
the-
my lord. 2 weeks from date.
No, we are making
One
it 1
week
week after
after the
vacation.
vacation.
Deeply obliged, my lord. No
1
issue.
week after vacation,
Reply.
reply if any 1 week thereafter.
Your
The matter may be
lordship,
mentioned
it
before
is my
the
submission.
next available circuit.
It is my submission that there is no need for filing opposition.
No.
This
He
matter
wants
may be
to file
heard.
after and prevent them.
My lord, it is my right, my lord, which I want to.
He will write something, sir. Why you are standing in the way? Let him write. We are
Then-
here to consider.
Then 2 weeks, 2 weeks from this date, 2 weeks from this date.
1 week from vacation, my lord.
1 week after vacation.
Yes,
Obliged.
my lord.
1 week after vacation, 1 week thereafter, and then you file.
Grateful.
Deeply obliged, my lord.
Our cue. 9. Mister, you are there for this matter.
For respondent number 4.
Long matter or short matter?
Very short, very short.
Now, what does you say?
Opposition.
My lord, very short. May I indicate, my lord? My lord, I have made a
What is
complaint.
this stand for?
Can
For the state, my lord.
My lord, it's for stay application. My lord, that is not needed.
That is not stay application.
My lord, very short. My lord, I have made a complaint for unauthorized construction.
Acha.
The learned single judge, without going into the merits of the matter, had opined that out of personal vengeance, this complaint was made, and that is why the writ petition was rejected.
Yes.
My lord, only thing, my lord, I am beseeching before your lordship today. My lord, the corporation is here. Let the corporation say that whether my complaint is right or wrong, valid or invalid.
Acha, show us the order.
My lord, order, my lord, kindly sees dated by
Private dispute.
18th of November 2025. Only to
So,
that effect.
Mr. Banerjee, you have Banerjee to.
No, Mr. Mondol, my lord.
Mr. Mondol,
My lord.
your writ petition has been thrown away saying it is a civil dispute. Now
No,
you have
my lord.
come up against that. You have come up against that order.
Yes.
And you have filed a stay application to set aside this order.
Yes,
They
sir.
must be given an opportunity to
Yeah,
reply.
my lord, very well. My lord, only
We will
if a
say-
report could be called from the corporation.
No, they will file the opposition stating all the facts.
Record that.
Yes, my lord,
Submit
if
that
the report, let a report be called for from the corporation, my purpose will be served.
Mr. Mondal,
If I have lied, said something wrong, let me be thrown out of the court.
yes,
I do not mind.
they will annex that in their opposition. You don't do
Report.
This writ petition, we file a writ petition
Oh, I
against
see.
appellant.
Oh.
They are saying it's a counter blast.
That is what happened. Bank passed an order directing municipality to see,
Oh.
and that is a counter blast and suppression of facts.
So, Mr. Did they file any, after that order which you obtained,
Yes.
did they file any reply?
No, they don't reply.
No, in that corporation was directed to, in
Yes.
your petition, corporation was directed to take appropriate steps. They have not taken.
Not taken, and we should contact notice of
Oh.
expiry of
Contempt application is pending.
application.
Oh, notice you have given. ঠিক আছে, এই শোনো order নিয়ে নাও।
My lord, my representation, my lord, dated 18th of September.
Sir,
My lord,
please,
let that be
let
considered.
No, how can we relegate it? Let them put it on affidavit. We will hear both of
Very
you
well,
and
my lord,
pass
let the
this.
corporation say whether my complaint is valid or invalid, whether
Naturally,
it has got any
they will
sanctity or not.
certainly say in their office.
I will be out of court.
Learned advocate for the parties that present. The application, this appeal is directed against the order dated 18/11/2025, passed in WP 295 of 2025 by a learned single judge of this court.
My lord, item 13 is
The
there.
learned
But
single judge by order dated 18/11/2025 was pleased to dismiss the said writ application on the ground that the dispute is between the two private parties. Stop. Upon hearing the learned advocates and considering the order passed by the learned Single Judge, we are of the view that the application for stay should be decided on affidavits, and the municipal authorities should state in their affidavit in opposition
The steps taken.
about the steps taken with regard to the complaint file and the inquiries made by them. Thus,
No, my lord. That is a separate proceeding. How can he claim, my lord, in my writ petition?
Municipality shall also file an, কি লিখেছো? Needs to be decided on evidence. Accordingly, the, বলেছো কি?
municipal authority.
Accordingly, the municipal authorities and the private respondent shall file an affidavit in opposition.
Within a period of 3 weeks after vacation, reply if any.
1 week, my lord, 1 week.
Within 1 week
Yes,
thereafter.
yes.
The matter before, the matter may be mentioned before the
আপনাকে তিন
next available circuit.
Yes.
1 week.
Your lordship, Mr.
The 3 weeks হলো opposition.
না না অপোজিশন উনি বলছেন 100।
Oh, 1 week.
3 weeks and after that.
ও আচ্ছা, you want to take 3 weeks?
Your lordship, item 11, Mr. Koko Kollol Babasu is appearing virtually. My lord, he is leading me.
The state is represented, my lord.
About the state.
In item number 9, state is
My lord,
represented.
item,
না দরকার নেই।
my lord, item 11, Mr. Basu is leading me. My lord, he is virtually, my lord, appearing. My
Virtually
lord.
we will hear.
Your lordship, kindly, my lord, very short matter. That is also a very short matter, my lord.
So which matter is long? If all are short,
No.
there is no long.
My lord,
No long matter.
my lord, Mr. Basu is appearing, my
Let
lord,
him
kindly.
appear.
No, what is?
Kindly, your lordship, my lord, my lord, the extreme urgency, my lord, my only means of livelihood has been, my lord, the forest department, what happened, my lord, I am running a sawmill.
Yes.
My lord, my forest department,
Approach the vacation, babe.
my lord, your lordship.
Yes.
Yesterday, my lord asked to mention it with medical document. What is the urgency? Item number 70, my lord. Actually, my lord, it was sent through phone and the lady.
Have you shown it to him?
Yes, ma'am.
Yes, madam. Document of the.
একটু ফাইলটা বের করে রাখো এটা। Wait, yes, yes, any other mentioning? Yes, প্রথমটা ডাক।
Item number 1.
You also, sir, do not point out whether there are petitioner or petitioner. Blame goes to the court. Blame goes to me, na? That the judge did not see this properly.
I'm sorry.
It becomes an embarrassment for us. I personally dislike these incidents.
Sorry.
Liखे now by Mr. Luksam, you have seen? You are also?
I asked, but that day only that told me.
He should have told, no?
Because they are doing something, I don't know.
Now I have to give a long line of corrections.
Yes.
Or petitioner has to be petitioners. Not only that, if I could have, I thought that it by incorporating two names I can pass the order. But the thing is, the order becomes meaningless. In one place it is petitioner, another place it is petitioners. By reason of a learned advocate appeal, ওই যেটা দেওয়া আছে ওটা বসিয়ে দিও না। ওই প্যারাগ্রাফ গুলো you have to wait. This will be corrected, it will be uploaded in the evening itself. The word petitioner has to be inserted in first and কত লাইন বলে দেবে, ওই যেগুলো সব দিয়েছে তারপরে নিচে লিখে দেবে this rectification shall be deemed to have been incorporated in the order dated such and such. The parties shall act on server copy of the order. And grateful. Need to look at the sheet to correction. No. Listen, Mr. Gandhi, you please assist my officer, because after correction you check up from my office. Yes, yes, call that mentioned matter. You are in next matter. I am proof. As the proof that wait.
Tomorrow time for the petitioner, right? Who's deputy?
That we have already solved now the order.
This is also affidavit of service.
Yes.
But allegation under my lord, under section 341, 323, 376, 511 and 34, my lord. And in this case, my lord, it's a counter case. My lord, in this case, filed on, my lord, 18th, and my lord, previously 9/11/2023, my lord, and same allegation, my lord, your petitioner, my lord, already filed an FIR in same case. In this fact, my lord, the de facto, my lord, take loan some, my lord, microfinance office and not repay. That's why, my lord, some incident, my lord, occurred. But, my lord, on 9th of November, your petitioner also filed a FIR, my lord. This is the copy, my lord. And
where have you stated here?
My lord, I'm not stated here, my lord. This is the
Since the wife and son has
already bailed, my lord. A 65 years old, my lord, petitioner.
That also you have not.
I
All subsequent information.
have annexed the other card, my lord.
Now investigation is over.
Charge sheet completed. Charge sheet submitted, my lord.
Now this 376 attributed to you.
376 is an incident done accounting since 2023 that I have
Is absolutely whatever.
123. That is a 164. Appearance of ER of WA makes it.
My lord, total false allegation, my lord, and this is also counter FIR. Okay. 9. Nothing material was, my lord, for allegation against 376, my lord. This is a my lord, nothing in my lord, medical or nothing. This only allegation, my lord, and same allegation, my lord, your petitioner also before 9 days, my lord.
Before 9 days.
9 days.
Against whom you submit? What was the allegation?
Yes.
This is who filed by whom? By your wife.
My lord, Shivendra's wife, your petitioner's wife.
And who had been the complaint against the lady? The lady was the complaint. And this objection was filed by your wife.
My lord, on prior to their FIR, my lord, on 9th of November, my lord, and this FIR, my lord, on 18th November.
Any identity for you that you must verify.
Didn't ask.
Just to ask and the for the petitioner submit the that the he has chosen submit right. Prior to the complaint lodged by prior to the complaint lodged by and then he came for the petitioner service, so the petitioner seated about
65.
The allegations are unfounded and the only rudiments of unfounded allegations the petitioner has reasoned. Now, there is a stop. After the complaint was lodged by the wife of the petitioner. The complaint was lodged by the wife of the petitioner on what is the date of?
9th of November.
9th of November
2023.
2023. Comma. And lots in complaint within
18th of November.
on 18th of November 2023 as a counter test. In the state conspicuous and as upon completion of investigations, that she has been subject to a conviction and may be granted an answer. Also when there is no, also when there is no possibility that petitioner shall be from justice. This some done waiting for state respondents opposes the petitioner's prayer, drawing the attention of the statements of the witnesses, statements of the witnesses. and surface that the and service that the involvement of the division and the alleged offense cannot be totally without particularly that is a very partisan next considering the nature of actions. The fact that an earlier complaint was lodged by the commissioner's wife against the hearing. The extent of complicity of the petitioner in the alleged offense. Period of the time of the opinion that the petitioner is entitled to anticipatory. However, its movement needs to be restricted. Allow 10,000 cubics one total. With the further condition that the commissioner shall. Where does the lady reside?
My lord, under Tufanganj police station.
You are also.
Same,
you
same.
Also Tufan?
Never, my lord.
With the condition that the petitioner shall reside outside the jurisdiction of the Tufanganj police, the Tufanganj police station. Until further orders and shall intimate the address where he would be residing. The officer in charge of the Tufanganj of the Tufanganj police station within a week from it. In the event of non-compliance details, we will cancel the bill without further. We have to better.
Grateful, lord.
Except court, yes, from the court. What side?
What is that one word?
What is that one word?
Yes, and inside outside the jurisdiction until further orders, except for attending the report below on the dates of hearing.
Grateful.
Item number 70.
Hello, I'm for the petitioner. I'm for the statement. Hello, no recovery from this petitioner. The recovery was made from one Mumtaz Sultana. This is the certified copy of the serial list, my lord, because the copy which I have annexed, that is some bit illegible. So if my lord sees the serial list, nothing has been seized from this petitioner, my lord. His name transfer only from the mouth of the co-accused.
Investigation over.
No, my lord, investigation is going on, my lord. CFSL report not received yet, my lord. Last day he has submitted.
To check the.
My lord, this is the 151 statement of the co-accused. We are awaiting the CFSL report. Investigation still in progress, your lord.
Hardly learned it. Apprehending at such Mr. Something learned it. We kept hearing for the original subjects. The definition has been falsely interpreted. His mother is suffering there. His mother has already been hospitalized and it's not really able to attend his mother due to the pendency of the support of such contention. Reliance has been placed up for the medical certificate. Medical certificate stock. Let me say we get one paper. Part of substance that there had been body of contraband substance about also contribution of the outside of the basis of the way you see is not state offices those and some investigation still continue. having hardly done it, it appears that there was no recovery of controlled substance above commercial quantity from the possession of the petitioner. And as such, the regards of section 57 of the Act are prima facie not attractive as the petitioner. Stop, his name has transferred on the basis of the point of those persons. Said conspicuous, I am of the opinion that the petitioner's custodial interrogation is not necessary.
Deeply ordered.
Accordingly, allowed the ground to proceed the further permission to the petitioner shall be the investigating officer once secure to the investigation is not application is put.
Deeply ordered. Put out the cover. Deeply ordered.
Item number 3 are for the petition. My lord, on last occasion, your lordship was pleased to give me a direction to meet the IO. I have and call for a report from the concerned IO. My lord, this is the copy that I have attended complied.
Yes.
Your copy. Yes. Yes, tell us.
Actually, my lord, for the case is concerned, that was lodged under section 156 clause 3 of all sections, stating inter alia that he invested 32 lakhs in share trading. That is page number 10, my lord. And that has been, I assured him to return back that money. I did not return the money. And page number 11, paragraph number 6. When he went to my house,
You are still invest.
I am working as a sub broker. He invested in the share marketing, and there was he incurred loss. He created pressure upon me, and so far the actual fact is that, so far the allegation is concerned, I threatened him for dire consequences. This is the whole about the allegation. It is not a case that I cheated him. I am an employee of a broking house, my lord. I have complied all the directions passed by your lordship.
The Bhumi can take a appealing for the petitioner service, that the petitioner is a sub-broker.
Sub-broker.
And the court and the defend and the complainant invested in large sum of money in a
share marketing, share trading.
In share trading. But he suffered huge loss. Money, you took the money from who to invest?
My lord,
did you take money from this complainant?
No, my lord. He invested. Just I opened an account in my company where I am the employee.
The complaint was the erupted loss. Exaggerating the incidents. As the same was not being treated as required, the complainant preferred an application under section 156 and pertaining to and pertaining to the order passed in the complaint was registered as FIR. Stop. The dispute has a civil profile, and the petitioner has been falsely the allegations are absolutely unfounded and he said consequences. You are a family man.
My lord.
Custodial interrogations are not paid by an strong. On the submission of the petition under no notice under section 35 bracket 3 of Genesis had been served. Considering submission of Mr. Bhumi that no notice under section 35 was served upon the petitioner, issued by an order dated that appeared before the investigating officer. That state was directed to file a as to whether the petitioner had worked pursuant to certification. Mr. Roy, for the state has placed before us, has placed the report of the investigating officer read from it appears. Read from with this report review. Considering the nature of acquisitions from the conduct of and the nature of acquisition, the conduct of the nature of use and the extent of complicity of the nature of the acquisitions and the dispute. So, the conduct of the extent of complicity of the of the opinion that his custodial interrogation is not necessary. Allowed in terms of the partner's provision, the petitioner shall meet with the investigating officer of the case. Once in a week in such investigations.
Grateful. Report kept with the.
Yes, we keep. Report came from them.
Item number 4. I have got a statement. Nothing has been recovered from my possession. Acting on a court
What can be recovered from your possession?
But even I am not in the spot,
What can be recovered?
even from acting on a source information, 3 persons were apprehended along with 21 kilo ganja. Above commercial quantity.
Not commercial.
No, that's above commercial quantity. They have been granted bail by the
Yes, start with some.
Lord, his name transfers from the disclosure statement of the co-accused person, Lord.
That she submitted. But he learned that cookie safely of this way. But he considered the materials from it appears that it appears that no contraband substance of commercial quantity was recovered from the position of and that his name has transferred on the basis of in thereof I obviously the regards of section 37 of the NPPS Act are not mentioned against the accordingly, I am of the opinion that custody of the position of the is not necessary. More so when for the completion of the investigation charge. Allow 10,000 is one.
Item number 5. I am for the statement.
Statement of pure commercial.
They are engaging in pure commercial matters.
21.47 gram of brown sugar recovered from another person. From his mouth. He is the principal accused. Is the. No, Chashit sir.
Principal accused is the brother of the petitioner. As per the statement of the principal accused.
It appears that no controversy after the civil option over from the additional channel, and that is saying has transferred on the basis of statement of the way first. Upon conclusion of investigation, studying view thereof, comma, time of missing comma, in regards of section 5 of this act, accordingly, I'm of the opinion that custody international personality not necessary. Most to be enough for foundation for this action has been submitted, allowed the yes, next. I will say on the period of not today.
Item number 7.
For the statement.
For the state 7.
Please.
A.
The state, sir.
Item number 9.
For the state.
Not.
10.
What day it is? NDPS.
No, my lord, this is 302. 302, my lord.
I have even an order. No one appears on the target is zero. Are the orders? No one appears on behalf of the petitioner and Mr. Chaudhary Ladder, appearing for the state is present and on the case in view thereof, as the last and to grant a partner opportunity, the petitioner will appear, better stands adjourned is the matter.
Grateful.
10.
40.
Item number 10.
In item number 10.
Time of the defect of the.
States under section 107.05 of the DA instruction. Lordship, in this case, lordship, kindly come to inquire lordship. In fact, the petitioner is only the trained of the common friend of the defect complaint and the petitioner lordship. He is only the as per to allegation, he is only the helping hand in between both the petitioner lordship. That is the only allegation. Full allegation against only the girl, namely Unnati Prasad. Unnati Prasad lordship. The love relationship, out of love, the deceased died by hanging himself. The petitioner is it is about 18 years, class 12 student. Lordship is going to pursue by this year ICSC examination. Lordship, I will search for his documents. Lordship, I also have
Just one. So the son committed suicide.
Son committed suicide.
Our body. Take your seat. Yes.
Lordship, deceased son committed suicide, having a relationship with the girl MT Unnati Prasad, and for whom Lordship this FIR made Lordship. I am the Neeraj Agarwal Lordship. I did not have any specific role about this case Lordship.
Now what has happened to Unnati? He has obtained regular bail.
No Lordship.
So no allegation against Unnati. Eh?
Not against
Unnati is the girl
God,
with whom the person who committed suicide was having an relationship. So the person has died, committed suicide. The girl has not been, no allegation against the girl.
Yes, Lordship, in the FIR.
She is also absconding.
No, not.
All of them.
Both are 18 years old.
And for the defect.
But the defect is Nitina, no, but the mother of
And for the
the
father.
mother-in-law's
This is
death.
minor.
Eh?
And for the father of the deceased minor.
Oh, minor, it was
Minor.
18 years. Yeah, that's touching it.
Your Lordship, the child is a minor. Are you abatement of suicide or minor is there? Now all these accused, they all are absconded. None has obtained.
No, Lordship, they are.
None has obtained. None has obtained bail. One for verification, your Lordship.
who are the accused according to you?
In the FIR. Your Lordship, in the letter of complaint itself, the girl, Unnati Prasad Chaudhary, her father, her mother, Deepak Prasad Chaudhary, Soni Jaiswal.
All are absconding.
And this particular petition, all are absconding.
No, my lord.
None has obtained.
They are preparing for HS Lordship.
Who is all your parents as well as you are preparing.
No, Lordship, they are just merely alleged in this case, Lordship, apprehended. Lordship, they are just falsely implicated. If someone get relationship, having
So
relationship.
trial and error method. Try your luck. If you get anticipated, I will come also.
Yes,
follow.
yes,
That's
that's
Lordship. February HS will be there. Lordship, kindly, Lordship. Kindly see these documents, Lordship. I have given Lordship. Kindly, Lordship. We have HS, Lordship. Kindly.
This is the complainant.
No, not that. He is the uncle of the deceased. This is the statement of the uncle of the deceased. In this statement, my lord, this present petitioner's name has come up. Investigation is going on, my lord. This is what's on that one.
Are not related with their family.
Madam, I heard. You are Nehal.
Neeraj Agarwal.
Nehal is the
Nehal is the
deceased.
deceased minor.
Oh, I see. Neeraj Agarwal. And anything else? Suicide.
Your Lordship.
Postmortem report is page 28. It's the postmortem.
Page
28.
What was the age of the boy?
17 years.
A minor.
Minor.
Same age.
That
Everyone
is
is same age.
another issue. Lord,
What is the issue there?
that he was the deceased.
Minor 17 years.
Madam, we release the matter. Then try your luck.
The deceased was a minor, and there is the allegation.
This was a minor, friend was also a minor.
No, but all these accused are not minor.
No, the person with whom the girl had relationship, he was a minor.
He was a minor.
He has committed suicide.
Yes, your lordship. Abatement of suicide is there.
Abatement of suicide.
From a minor.
How Neeraj has compelled this suicide?
All these together, your lordship.
Suppose a person, he had his name figures. There must be some corroborative evidence that he has instigated this person.
Your lordship, that is one issue. One more issue there.
It is a case of which Each month. Investigation has not yet come.
No, my lord. 30th October 2025. Investigation is going on.
And you are a minor. You are not
I
a
just
minor.
touched 18.
Huh?
By this year, I have just touched 18.
So when is your exam?
February. This is the registration of
I will ask, I will compare his attendance before the.
One more thing. We have prepared a read petition. We have prepared a read petition. Now there is already a direction to submit a report of investigation because one of the principal accused, his name is there in the letter of complaint. However, his name has not been put in the FIR. And we have prepared. Let me complete. See, Your Lordship.
This was 6th November ordered.
Yes, Your Lordship. When we throughout after the incident, throughout we have complained to the higher authorities of police.
What has happened to this case?
This one, there is a direction for submission of report.
Then what happens? Report submitted?
No, report has not been submitted, Your Lordship.
The matter did not appear thereafter.
No, the report is yet to be submitted. It will take up the next survey. Now, till the report is submitted, then the.
Oh, this matter will be in the next cycle.
Yes, Your Lordship. 4 weeks is there.
So we then try.
Yes, Your Lordship.
Next cycle. You are sure we will record that on this petition? Fact, your de facto company.
Yes, I am de facto company also. There.
Or ready to argue before the next step. Yes, showing the order that the report comes, report will be shown to the board. Yes, next.
I don't know, 11. Okay.
Why, Mr. Pontaru?
Hello.
Did it up finally? Huh?
11. 11. Not pressed.
On the prayer of the Lord and the appearing for the petition. Petitioners. Comma, the application in such and such is dismissed as law. No, no, you are appearing.
Yes, sir.
Number 12.
Civil disputes between groups.
That we call it the civil dispute cases, Mr. Bhumi. Huh? All civil disputes.
Unfortunately,
Civil profile, criminal profile being given.
unfortunately, that has been come to me.
Unfortunately.
Fortunately, my lord.
Mr. Roy is standing there, handing over to me.
You can give it to me.
Go, Mr. Go.
No, my lord, actually,
Material instruction you transfer.
my lord, actually, if your lordship kindly take some pen to go to the page number 10, 12, your lordship will find.
Yes, 156 complaint.
No, my lord, this is a written complaint lodged by the people, the police officer. Stating inter alia that they got a civil court degree in the year of 2005.
Who is the complainant?
Complainant is, my lord, one Pradip Kumar Agarwal.
The Protein Institute is a suit.
Prahlad Roy Agarwal, his uncle.
No, no, Protein lost.
Pradip lost now.
So allegation was that the interim order was not being complied.
Right. But now, my lord, subject to lordship correction, your lordship.
Extortion of money, why it is being said?
They said I took building materials from his premises amounting to rupees 8 lakhs in daylight. And when they returned that, I demanded rupees 10 lakhs. Actually, my lord, there are 6 and CBS, several civil cases are pending. Now, If your lordship can you take the page of 15?
No, who are all these persons? There are 4 persons.
There are 4 persons.
Complaint was lodged against 4.
4 persons.
Oh, अच्छा.
Now, my lord, can you see?
Title suit. No, title suit was between these parties.
Two title suits were there. One is 672 lost by them. One is 690 that is lost by ourselves. That is page number 15 and page number 31. Page number 15, they filed civil suit against me. Page number 31, civil suit lost by one of the petition. In both the cases, the trial court was pleased to pass an order of status.
Then
now both the matters are hard analogous.
What were the suit was? Declaration and injunction.
Declaration.
Both.
And we are demanding that that plot
Same
plot. We are demanding the plot belongs to us. They are demanding the plot belongs to them. Over the same issue, 2 civil suits are pending. That is page number 15 and page number.
Then what happened?
Now the matter is pending for head.
Now what is the substratum of the complaint? Why the complaint was lodged?
Complaint was lodged just to make a case more serious and disposes us from a peaceful position.
You are in position.
I am in position.
Yes, sir.
Lordship, kindly peruse the rejection order.
Rejection order.
Rejection order.
Yes.
Para 1, Lordship, in there. Yes, Lordship. Para 1, 2. From the materials available before this court.
My lord, I have annexed the copy. Rejection order passed by the running section.
Lordship, I'll give the.
Page 51. Page 50. Yes, got it.
Yes, Lordship. Now kindly.
6 November.
Yes, from the materials. Yes, 6 November 2025. From the materials available before this court, it appears that the complainant is a decree holder, but the accused person deliberately, willfully, and influentially violated the order of the court and caused damage to the suit land of the complainant. The allegations are very serious in nature. Specific allegations have been leveled. So that is the allegations regarding. Yes.
Broken. Specific that they broken.
Vandalized the constructions of the complainant and took away building materials.
They were in position, they are saying.
I have also civil suit. 31.
This is the allegation which is there in the case diary itself. There are 161 statements.
Building materials.
Open
Worth rupees 80 lakhs. 8 lakhs, Lord. My apologies. And demanded 10 lakhs from the complainant to return the same.
Now, my lord, one indictment I am seeking.
Wait. Any injury report?
No injury report.
My lord, they have
Now investigation is still going.
Investigation is still going on, Lordship. And page number 27, it has been considered while delivering the judgment, Lordship. Son of the complainant victim, page 27. That is the 161.
Page
27 of the case diary.
That there was.
Yes, there was a couple, and yes, the allegations which are placed in the record, Lordship.
And his present the normally done a identity for the allegation as subjects that they have been subjects that the petitioners have been falsely implicated on the motives of vague allegations. The vague allegations and exactly falsely vague allegations and upon exaggerating the incident that took place, exaggerating the interest admitted there is a 2 civil suits are pending amongst the parties. And we dispute is primarily, then the dispute primarily has a civil profile upon civil profile. So in the said conspirators, custodial interrogation may not be necessary. Still looks some learned as ability for the state opposes petitioner's prayer and draws our attention to the statements of the witnesses as well as the order passed by the special judge rejecting the petitioner's prayer for anticipated evidence. This was celebration. Which appears, simultaneously appears amongst the parties as a civil profile. There are two painting title suits amongst the parties. Stop. In the case diary, there is no document, there is no injury. Considering the nature of accusations and the history of the nature of acquisitions and the extent of complicity of the petitioners in the area. I am of the opinion that their custodial intervention is not necessary to stop. However, their movements need to be restricted. Allow 10,000 with a further condition that the petitioner shall meet with the investigating officer. Once the investigation is completed. Yes. Yes.
Item number 30. Not answer. My lord, then the matter with each other next proceed. Okay, so.
Not. An adjournment has been prayed for on behalf of the state. To Mr. Mohol and a deputy appearing for the petitioner is now. This is the matter before the next state. Yes, next.
Item number 14.
No, I'm for the petitioner.
Who is opposing him? 14, who is there for the state?
Mr. is there. Mr. Yes, sir. Yeah.
Is he here?
He was here only.
In the morning, I have seen him in the court, my lord. He was appearing.
Catch hold of. Pass over. Yes, next.
Item number 15.
You are there?
Yes, Lordship. Lordship, in this case, Lordship, from the petitioner, nothing has been seized. Lordship, therefore I pay for bail, Lordship.
And how did your name come from?
From during the investigation, Lordship.
Yes, Mr. Nixon.
My lord, from the Bangladesh border, my lord, some people were seen absconding, Lordship. From there, one gun was recovered, and there are one.
Gun was.
Yes, a gun was recovered, and there are 161 statements of the witness.
Recovered from this person was not apprehended.
No.
Not yet.
No. On being produced by so and so, 4 live ammunitions were seized from that spot, Lordship, and place of seizure at the time.
Straight away, what?
Lordship, I am not.
You handed over the gun to your friend and played out.
No, Lordship, that is not, Lordship.
The problem is, Lordship, in this case, since the guns have been recovered, my objection is that because he might be a supplier or he might be somebody who might use that weapon also.
On the basis of only suspicion, Lordship, I am not present there.
So, investigation complete.
Investigation is not yet completed.
Any antecedent?
No.
Antecedents, no, Lordship.
No.
What are the sections?
It is under the Arms Act, 25(1)(a) of the Arms Act.
The seizure was from the.
Seizure was from the spot, Lordship. Seizure was from the place.
And how many persons were taken?
3 persons were taken.
They were apprehended.
They were apprehended, Lordship. Right. Absconding, and Mithun Mia is the person who has been shown arrested, and he is Jahangir Mia. So there might be a connection between Mithun Mia and Jangir Mia.
How?
Because he was shown arrested, he was already arrested in other case. In what case he has been arrested, we don't have any information, but the other co-accused,
Mithun Mia.
Mithun Mia.
That is Mithun.
I'm just trying to establish the connection. Yes, I'm just trying to establish the connection between Jangir and Aminul because they were also present at the spot. Mithun was not present, but under his instructions also he might be present at the spot. So it is a question of interrogation, Lordship.
Only on the basis of suspicion, Lordship, and statement made by the Mithun Mia, who has been arrested.
What is 25(1)(a)? Arms set.
Lordship, without license using the firearm. Lordship.
25.
Apprehending arrest the present application has been referred to. Where would it appearing for the petitioner's service? That the petitioner has been falsely indicated. He was not in the spot and there is no material. And merely on the basis of suspicion. And merely on the basis of falsely indicated. He was not in the spot. He was not in the spot, and his name has transferred on the basis of a co-accused statement. And the petitioners have no manner of involvement in the arrest offense. Stop. Such Mr. Nixon and the for the state opposes the petitioner's prayer. Is it for the petitioner's prayer? And submit and drawing the attention of this court, the statement of the witnesses. And submits that the involvement of the petitioners in the arrest offense cannot be totally ruled out, also when the investigation still continues. But we have to be respected for this, considering the nature of accusations. And the fact that the petitioners nature of and the fact that the petitioner's names have transpired on the basis of the co-accused person. Considering the nature of and the extent of complicity of the petitioners in the arrest. I am of the opinion that custodial investigation made of patients is not necessary. However, the movement of the petitioners needs to be restricted. Accordingly, also research with a further condition that the petitioner shall meet with the investigating officer of the case twice a week and shall decide within the jurisdiction of Shitai police station. Till the investigation is complete. In the event of non-compliance, cancel.
Grateful. Grateful.
My lord, I am on behalf of the petitioner, my lord. My lord, allegation under section 85, 109 clause 1, that is corresponding to 498 and 307, and read with section 3 and 4 of DP Act, Dowry Provision Act. Well, I am the husband, my lord. I am the husband. Rest of the alleged person are on bail given by the learned session judge, my lord. My lord, kindly, my lord. And my lord, as per the instruction I have received, the de facto company is residing with the present petition, that is her husband, my lord.
And as per my information, defective complaint and the present petition are deciding together.
Deciding together.
Merry Christmas.
The same house.
And my lord, as per the allegation,
Married son.
back in the year 2022, my lord.
Does the complaint?
Wife.
Lady.
Lady.
307 against who? 307.
It is, my lord, as per the allegation is what is the omnibus allegation. Can you see the FIR, my lord?
Yes, Mr.
Yes, there is one injury report.
This internal dispute occurred. It has been amicably settled between the de facto complaint and the petitioner, and they are now deciding together.
Everything and is the present. That giving an exaggerated account of the alleged incident, the complaint was lodged on the board against the petitioner and others. Petitioner by his wife being the de facto complaint. Stop. There was the petitioner, the presently, the dispute has been resolved. And the petitioner and the de facto complainant are deciding together. Stop. In the said consequences, the custodial interrogation may not be necessary. The learned advocate appearing for the de facto complainant submits that does not deny the fact that the petitioner and the
Important.
complaint are presently some learned advocate appearing for the state has drawn the evidence on the statement of the witnesses and the injury. The further submits that investigation is on this. Considering the fact that the petitioner and the complainant are deciding on the nature of acquisitions and the extent of complicity of the petitioner in the I am of the opinion that custodial negotiation of the petitioner is not allowed 10,000 to one local officers with a further condition that the petitioner shall meet with the investigating officer of once a week till the investigation is complete. Allowed.
Grateful much.
Number 17. I got the opposite party number 4.
Again, objection there. Petitioner. My lord, I am for the petitioner.
ST Act, was in the section 18 and section 81 Act.
আরে ভাই আমি জানি ভাই আমি প্রসিকিউশন অনেকদিন করে এসেছি আমাকে এটা বলতে দিন না আপনি my lord my submission is that a notice under section 35(3) has been issued to the accused persons matter. So we have already complied with the notice. We are waiting for the compliance report from the police. So let it be fixed before the next circuit so that we can appear before the court with the compliance report.
How many persons are there?
5. 498A with 4. Yes.
Mr.
Compliance will come back with the compliance report.
Mr. Vishwas admitted appearing for the petitioner's praise for an adjournment to date as notice under section 35(3) of BNS such and such has already been issued to the petitioners and in compliance of the same they would be appearing before.
No, they have already appeared.
And in compliance of the same they have already appeared before the investigation
Officer and the compliance report, the token of compliance, that token is awaited. That has not been given.
However, the document of such bank.
Document acknowledging may appear.
Submits the, I don't know, submits that, stuff. Yeah.
Yeah.
What is the, you, that ID you can produce?
No, madam. I will produce the compliance report from the.
Compliance report of his presence, Sachi, if he wants to produce on that day. That he has already.
Probably, my lord, I instructor, they have not appeared. How do you know the instructions in the IO? You're interfering with the investigation.
Not fight on. Mr. No, learned advocate appearing for the petitioners placed on an accommodation to place before this court the compliance report. Compliance report in response to the notice under section 35(3)
of the BNS.
One thing,
for the one thing, they are.
If you been there, yes, one thing.
According to their submission, they have already complied. The problem are my instruction, they have not.
Then it will come on that day.
That may.
Mr.
Or this person.
Opposes so opposes such prayer of opposes such prayer. So Mr. Nixon, that state is also present in order to grant an opportunity of place before this the compliance.
Mano, since he is disputing my whether I appeared or not, let the state comment on this on the next day. Let the state.
Fine. हो गया तो.
No, I mean, preliminary option was so that I think Section 18 and 18 bar. Bar is not absolute, Mr. Because there are Supreme Court judgments. Yes, he can come.
Was an absolute, Mr. Roy. CST was absolute.
Yes, sir.
Subsequently diluted by the judgment.
Yes,
But I think very recently another judgment has come. I have not been able to.
Go through it. Yes, sir.
The issue is, it is not that the issue stands on the list.
No, only question, prima facie case is not maintained.
Yes, next.
Number 18.
Miller, time for the question.
Yes.
Miller, we were in a long-term romantic relationship, Miller, with the de facto complainant, Miller, and it is almost 8 years, Miller, of long-term relationship, Miller, and
self-tortures,
Miller, and during those period, Miller, there was a consensual relationship between myself and the de facto complainant. That is the allegation, Miller. And in the year 2017, Miller, there was agreement between the de facto complainant and the petitioner, Miller. That's case number 12, Miller.
Since when you are having such views?
Uh,
You are adult.
Both are adult.
Both are adult.
Both are adult, Miller. And Miller, that there is agreement, Miller, in the year 2017, Miller.
What
agreement to remain separately, and that de facto complainant had demanded some money, Miller, in the local community. They are tribal, Miller, a panchayat, Miller. And if that money was not given, Miller, she would going to file the complaint, Miller. And this is the result of that complaint, that she filed that complaint in the 19/6/2025, Miller. And this is the case, Miller. And I'm relying upon one judgment.
96/2025 complaint was first alleging what?
Alleging that he made promises to marry Miller, but he didn't marry. And I was in 8 years old relationship with him, Milord. And presently he flew away with other girl, Milord.
164 of
I am relying upon one judgment of the Supreme Court, Milord.
for what?
Consensual relationship, Milord. Page 2, Milord. Last paragraph, Milord.
This was anticipated.
Yes, Milord.
Nothing laid down.
But it has considered, yes, consider consensual relationship.
How
And there are many judgments, Milord, wherein that consensus, on the basis of consensual relationship, Milord, rape case has been this squashed, Milord. Just because I didn't pay the money, say file this false complaint, Milord, in the year 2025, Milord. But my relation was till 2017 only, Milord.
Milord, can you see the 164?
See, this is in
Hindi.
Hindi. You can read Hindi.
Lordships,
Some
yes,
portion
looks for here, your Lordships.
there is a allegation of pregnancy also there.
There is an allegation of
Pregnancy.
pregnancy. Where is the medical report?
Medical report. Their medical report in 32.
32.
Of which year?
2010, that was
This was of 2020, no? 25. Then pregnancy was not noted.
not noted.
Not noted. They went from your officer.
That is in 164.
Yes, Mr. Now investigation done or continuing?
Continuous.
Not submitted, Lordships. Charge sheet not submitted.
No, that's no problem.
Okay, what I do is I'll just write it down, a piece of paper, transfer to this examination, 65 minutes.
No, please read out করলে মজা হবে।
मैंने একটু এটা লেখা আছে मैंने अपना प्रेगनेंसी भी वॉश आउट कर दिया, हमको वॉश आउट किया था,
उसने खुद ही नहीं,
वो हमसे पैसा मांगता था जब वो मुझे शादी नहीं किया
करना चाहता
था after holding the hearings, then the question has been prepared. Still probably learn that anything else?
No.
Learn that would be waiting for the petitioner's service. That both the petitioner and the defective complainant are adults. There was a love relationship between them
for the period of 8 years.
For about a period of 8 years. Thereafter, Alleged complaint was lodged by the complaint. Falsely implicating the petitioner by giving an exaggerated account of Mr.
I am appearing.
Mr. Shortcut for which state opposes the petitioner's prayer and submits that there are intimidating materials on record against the petitioner. And the petitioners and the petitioner's implication cannot be totally ruled out at this stage from a also when upon investigation. Also when investigation is still continuing. Party targeted basically for the respective partners. I consider the concerns and stuff.
prima facie whether free mixing among the petitioner and the de facto complaint for the last for about a period of 8 years prior to the incident was actuated with dishonest intention. With dishonest intent or deception is to be assessed at the appropriate stage of the proceeding in accordance with considering the nature of acquisitions and the extent of the petitioner I am of the opinion that custodial interrogation is not necessary. However, his movement is to be restricted, allowed with further condition. Where does the girl reside?
In the same locality, my lord.
With a further condition that the petitioner shall not reside the further condition that the petitioner shall not reside within Bagdogra place. Within Bagdogra place. Say and shall not enter the jurisdiction of Bagdogra PS. 7 except for meeting with the investigation officer of the case. Once a week till investigation is complete. Because in the event of non-compliance, bill to be cancelled.
Millard, small indulgence, Millard. He is a Christian, Millard. Let him allow to celebrate Christmas with the family, Millard. Tomorrow or one day.
That can be ignored. Religious.
The further condition that on and from 5th January. On that becomes an office. What is the age of the lady?
34, actually.
34.
Yes.
And what is your age?
32.
Further condition that petitioner shall meet with investigating officer. Once a week, the investigation is complete. I want to submission that please submit. So like Reliance has been placed on an article delivered by the Supreme Court in the case of Howard Singh versus Tikam.
Grateful me.
And then number 19,
I'm for the state. But allegation under section 341, 354 of the Indian Penal Code. 340 or 354. Honest. Allegation is that on 15 November 2025 at about 5:30 p.m. while the informant was returning home by her bicycle at that time near the ration shop, this petitioner allegedly restrained the informant and took her to a nearby jungle and outraged her modesty. That incident allegedly happened on 15th of November. FIR has been registered on 23rd of November, after 8 days. But in the FIR, there is no delay, there is no explanation regarding the delay. Why she lost the FIR after 8 days. Another point is that all are magistrate tribal offences. 41 a notice did not issue by the police authority to the petitioner. On 341 is a bailable offence. 354 is only non-bailable offence. And there is both are the neighbor. There is a neighboring dispute, and for that reason, for this false complaint has been started after 8 days. if situation is allegedly was occurred, why she did not lodge on the next day? After 8 days, this incident was done.
Yes, sir.
Yes. Blood, this petitioner, blood, while the victim girl was going to a tuition, so she is 19-year-old. 19 years old.
Oh, and this one?
Blood, he is aged, blood, and I have to check, blood, but he is probably 30 plus. But blood, while the lady was going to the tuitions, blood, on her way, blood, she was abducted, blood, by this petitioner. She was forcefully taken towards the jungle for the purpose of committing rape. Blood, while she screamed, blood, few local persons, blood, who were passing by, blood, they have heard, they have intervened and saved the and saved the girl. And during that time, blood, he fled away. Blood, while fleeing away, blood, he groped the victim girl. There are two eyewitnesses, Milord, who have specifically stated that while he was fleeing away, he groped and he went away, Milord. This is the statement of the victim girl. Kindly see. But case is of 15 November, Milord. Very recent case.
Complaint after 8 days, then,
19-year-old girl.
But kindly see why.
Immediately she is molested.
There is no explanation regarding the delay. But kindly see.
Kindly consider a 19-year-old.
But if the
girl,
Mansi report,
suppose a girl in our society is molested, whom she will go and say first?
Malad,
To the parents.
Malad, that is true, Malad. But it must be a
question of-
false allegation also, Malad. It
Yes,
can
yes,
be.
right.
It can be, Malad.
There can be a false
Then,
allegation
Malad.
which has to be rooted out. All criminal investigation at the inception is based on suspicion.
But my humble submission is that, Malad.
Yeah,
If
you
that
understood your
if
submission,
that
but
serious
cannot
incidents
be-
would happen, Malad.
No, that you are trying to say that this 9 days delay
Yes.
is for the process, for the purpose of falsely implicating me by exaggerating the.
Yes,
This
Malad.
is
That
your
is
allegation.
yes, Malad. And 41A, Malad, Princeton tribal case, Malad. No 41A, Malad.
No 41.
Milord, that I have not seen in the case, that it's not there.
No 41A, Malad. But this
But
mandatory.
in the second last paragraph, she categorically mentions about the dropping.
Malad, there is 41 is mandatory, Malad. Give me the notice 41. I cooperate with the investigation, Malad. I meet the IO, Malad.
You are a married person or you are unmarried.
Malad, I have to take instruction, Malad. In this regard.
The two eyewitnesses are also there, 9 and 10, Milord.
Why then that 41 not issued, Mr. Chudhi?
But that instruction has to be taken from the investigating.
Then the matter goes big side.
Yes, ma'am. As per Arnesh Kumar, 41 is Malad, is mandatory, Malad.
But CD does not say anything on that, Milord, so instruction has to be taken. A very recent case, Milord, it's 15th/11, the opportunity is still there, Milord. It's not that the opportunity has gone.
I Malad, 41 notice I cooperate, Malad. I speak.
Next sir. On the prayer of Mr. Chudhi and the deputy appealing for the petitioner, for the respondents, on the matter stand adjourned. Is the matter for.
Grateful.
Yes. Now, I am reading what is that judgment you are saying.
My judge.
That not required.
No, I no judgment. No, I said that it's 15th/11 case, so the opportunity is still there. It can be given.
No, you said now that the Supreme Court order you said.
No, I am Arnesh Kumar.
He said Arnesh.
41 is.
I on the issue that 41 way, even if not issued, you can enter into that. Anything contrary to.
No.
Arnesh Kumar goes to further extent, and if you don't give, your officer will be ordered.
Yes.
Disciplinary
That's correct.
proceeding will be initiated against
That's
for unnecessarily harassing the person.
no, Lord, only I said that the opportunity is still there. It can still be given. It's only 15th/11.
I am also praying that, Malad. Kindly keep notice.
Item 20.
Malad, in item number 20, at first, Malad, I am not pressing this application in respect of Malad petitioner 1 and 2. They have been arrested, Malad, during pendency of this application. Malad. 1 and 2. One is Govindo De and 2 is Vishnu Rai.
Allegation is?
Allegation is that, my lord, these three petitioners, my lord, as per the FIR, three petitioners went to the house of the informant and, my lord, started abusing the son of the informant. And subsequently, my lord, allegation is that the son of the informant was assaulted by these petitioners, my lord. And, my lord, they are the neighbors, adjacent neighbors. But
So now, who is this Govindo and Vishnu are father and uncle?
Govindo and Vishnu, my lord.
Who have been arrested?
Govindo and Vishnu.
Govindo and Vishnu, what is the relationship with Munna?
But actually, my lord, they are the, my lord, very family members.
My lord, without wasting the time of honorable court, kindly see the medical bill.
Neighbor.
Serious allegation.
Yes, my lord.
But kindly see my involvement, my
Very
lord.
serious,
Munna Rai, my lord,
I have
kindly see.
vehemently object the
But kindly see
application of
the
the
state, my lord,
administrative bill of the
implication of the
petition
Munna Rai.
serious allegation. Kindly reject the appeal.
Where is the statement of this?
Statement plus share.
Just 2% of
My lord, neighbors statements are there, my lord. Neighbors.
Complainant is Deepa on Kodomot.
My lord, no, my lord.
No.
Complainant is, my lord, the
Mother of the Deepa.
mother of
Manushi Borman is a complaint.
Mother of
the
Deepa, but mother of the victim.
Deepan statement is here.
No, my lord. Deepan statement আছে Deepan statement আছে কোথায় এই যে না এটা নেইবার বলা আছে না নেইবার্স দেখ ভালো মানে নেইবার স্টেটমেন্টস আছে ইনভেস্টিগেশন স্টিল ইন প্রোগ্রেস হয় so we have
But
the
at any
opportunity
condition.
we have the opportunity
But at any condition, kindly see my involvement, my lord.
চুপ করে বস
এই করোনা নামে জুতা হ্যাঁ বলতে তো
নির্বাচন 161 চেষ্টা করুন ওই যে
9, 10, 11. 9, 10 and 11. The neighbor statement.
the neighbor statement
Is neighbor 9, 10 and 11?
9
Yes,
yes,
Lordship.
এই তো এখানে অ্যারেস্ট কথা লেখা আছে ওগুলো অ্যারেস্ট হয়ে গেলে বেচারা
হ্যাঁ
ওগুলো তো তোমার অফিস করতেই হবে
করছে তো
Clearly, Harris present application has been filed. At the inception, Mr. Rule Ahmed advocate appealing for the petitioner's appeals. That the petitioner number 1 and the petitioner number 2 had already been arrested. Stopping being thereof, the present application for cancel for anticipating with so far as the petitioner numbers 1 and 2 are concerned. Is dismissed as infractions. He further submits that the petitioner number 3 has been falsely illegal. In the alleged incident, no specific overt act has been attributed to him. In view of no specific and as such, custodial interrogations may not be necessary. And he may be granted and because Mr. Acharya getting for this state. Houses the petitioner's prayer and draws the attention of this court for the statement of the witnesses and the injury report. So from the injury report, it appears in the injury report, it has been stated that quote unquote no external injury that is in view thereof and as the allegations prima facie appear to be omnibus in nature. I am of the opinion that custodial interrogation is not necessary. Is not necessary. However, his movement needs to be restricted or the investigation is still not found, still continue. Allowed with a further direction that conditional number 3 shall meet with the investigating officer of the case once a week until the investigation is complete. Allowed.
Grateful.
At 21.
My lord, item number 21, I appear on behalf of de facto complainant, my lord.
He has taken an adjournment.
Great.
Yes, next.
Item number 22 and 23.
My lord, complaint for next, sir. 22 and 23.
Any matter where both sides are here?
Yes, Lordship. Lordship, item number 24, Lordship.
Item number 24.
Yes, Lordship. Lordship, under section 126 to 115 to 117 to and 109, 351 and 35 of BNS Act, Lordship.
T5 of
BNS. Common intention, Lordship.
what was the crime?
But in
Yes,
IPC,
sir,
my lord, 341, 323, 325, 307 and 506.
170.
No specific allegation, Lordship. All the and Lordship, wrongful extent and use filthy language and Lordship to protest the matter and they physically assaulted the complainant, Lordship. That is the allegation, Lordship. ব্যক্তিগত statement আছে? ব্যক্তিগত statement? Charge has submitted, Lordship. Yes, Lordship.
But my lord, the two victims are there, my lord. One is simple and second one is, my lord, grievous, multiple cut injuries and active bleeding.
Lordship, kindly page number 19, Lordship.
I am showing
The charge sheet, Lordship.
these are the,
During
my lord,
investigation,
two,
Lordship.
continue pages, my lord.
Lordship,
This
then
is
I
the
say-
first one is the simple, second one is the multiple cut injuries and active bleeding, my lord. This is the first one is the simple.
This is the second one.
No, my lord, this is the first one. Kindly see the
Plant trauma and
second page, my lord.
plant injury on head. Multiple
Cut injuries.
6 stitches.
And my lord, active bleeding.
Lordship, kindly page number 19, Lordship. I was during investigation, Lordship. Then I sent a prayer for injury report and collected the injury report from doctor. His opinion that one is simple and other referred. But the complainant, she retained her statement, brother not treated any other hospital or not any admitted any hospital, Lordship.
না তো নষ্ট হয়ে গেছে
But the complainant
She retained statement.
monitoring.
Her statement, Lordship.
Her brother not treated in any other hospital.
No.
So how this will vanish? This is the exact account. This injury report.
Lordship, charge sheet has been submitted, Lordship.
Stitches.
No, Lordship, investigation already completed. Kindly, Lordship.
In view of this injury report, how can I give, sir? There was active
bleeding,
6 stitches given.
multiple cut injuries.
Lordship, kindly, Lordship. Any condition, Lordship, any extension condition, Lordship, kindly.
Sir, if you saw this, try your luck in the next. in course of hearing and adjournment has been paid for by the Honorable Deputy appearing to your name.
Because you know.
Mr. Singh, Canada, if we were necessary instruction.
Grateful.
Stop Mr. Rajan to learn that we can interest evidence on behalf of its. Stop these matter. As the last chance, common matters, I do stop these matter for the next available side. Yes. Any matter where both sides are clear? 27. 27, dictate about 25, 26.
25, 26.
Yes, 27.
27.
27, I am for the two petitioners, Miller. And yes, Miller.
The problem with this petition is that, Lordship, the WPA has already been issued. It is a case of 2019 that I had prayed for issuing WPA on 2021. Now it has been issued. It is not maintainable now.
Miller, poor lady Miller. And
WPA issue.
but they could consider.
How can court consider WPA after issuing WPA?
Yes. Yes, any matter where both sides are here?
My lord, item number
32.
My lord, item number 30 and 31. Lordship, item number.
He is not present.
My lord, item number 30, Lordship, my lord, this matter, my lord, I want to not press this application. Item number 30. 30, 30. And Lordship, I want to proceed with item number 31, Lordship.
Item number 30.
30, 30.
30, we learned it, we still learn of this. Learn it at repeat for the one.
One.
Stop, your stop means. On the prayer of the application for admission being such and such, this is not risk.
Grateful.
30 not makes yes.
28, I'm praying for next circuit, your lordship.
All right, 31, which is yes, which is your matter.
31, Lordship, 31, Lordship, Mr. Kollo Lajaj, I think he is appearing for the state, Lordship. I want to proceed. If your Lordship kindly permit.
You want to?
Proceed, Lordship. I want to proceed.
Proceed.
31.
She wants to proceed at her own risk and cost.
No, just now I have received the case diary. I have not checked the case diary.
Exactly. Yes. 32. Yes, 32 is opposite.
Aniruddha.
Aniruddha.
But he is feeling not well. He left the court.
I am also leaving, he is also leaving. But instead I am not sick.
My lord, leaving tomorrow.
Yes,
For Calcutta tomorrow.
all secrets cannot be done.
in open court.
Welcome to all you to the new building which is soon coming up.
Yes, my lord. We are also waiting for the 17th.
Happy New Year.
The building.
Yes, my lord.
Merry Christmas. Happy New Year.
Fantastic building. Fantastic. Yes, yes, ma'am. Fantastic building.
Have you seen the chief's house?